Well, item number 4, my lord.
Yes.
Well, if it is not inconvenient, your lordship can, lordship slight accommodate for 2 weeks, my lord, because we have to.
Yeah, it is
Yes.
for orders. Why?
Yes,
You're for?
I am for the petitioner in this case.
Well, it is for orders. What is the purpose, maybe?
I think the last time Mr. Singh was there because this matter, initially I was handing thereafter, I was not in the picture.
Since it is for orders, let us check the file, Mr. Singh.
For hearing, I don't know, please. File.
Orders.
Have you checked the records, court file?
There is an order. Yes. Last, I think Advocate General was informed. I think he was not in this case. He was informed to appear in
There is
this
a-
case. I think.
Statutory provision under challenge, so that is, I was.
In the form of PIL?
Well,
We'll just check the records.
there appear to be a lot of IAs in the.
I think we find it. But that's I think I post the or something.
On 19.5. 19.5 for what purpose? Affidavit in reply not yet filed by the petitioner. You would like to file affidavit in reply?
We have to file it.
Then we can, for that purpose, we can adjourn it.
Yes. Sir.
Because there's an officer of 17.5,
Yes.
recent origin.
Hmm.
That affidavit in reply not filed.
Why
Third,
they file it?
3. D. Das learned senior counsel for the petitioners, assisted by Sri A.K. Singh. Also heard Sri I. Chaudhary, learned Advocate General of the state. Para. Sri Das, the learned senior counsel, prays for and is granted 2 weeks time to file the rejoinder affidavit. List after 2 weeks.
Cannot date be given.
Tell us. List on
16.
16.
16, as requested, list on 16.6.
Well, there is one matter in the supplementary list.
Yes.
This has come by order, my lord.
Yes, yes, we've seen.
I was not aware.
Hmm.
I have not brought the brief. So, can this be fixed next month?
Parasuram.
Parasuram.
Yes, Mr. Ratan. Oh, you cannot appear now. Who's there?
I'm for the assistant.
After a week?
Lord,
be
I
next
am
Monday.
appearing in
Next Monday.
Parsuram, Lord.
Okay,
I am
You're for-
appearing in
you're-
Parsuram Cement, Lord, petitioner.
okay. We'll have it, we give a date in the next week?
Can
Lord,
it be
my
on
only
26?
difficulty is that they are going to hold auction on 28th, Lord. So any date before that they
Yeah,
may.
you suggested it before that?
On 26, my lord, I have to be here anyway.
26.
26,
Yes.
26, Lord.
Okay.
Deeply
What is your good name, please?
Naveen Kumar, Lord. Naveen, N-A-V-E-N.
Naveen Kumar.
Naveen Kumar.
Yes.
Third, Sri Naveen Kumar, learned counsel who has appeared online for the petitioner. Also heard Sri I. Chaudhary, the learned AG, Arunachal Pradesh, who however prays for some accommodation. Para. The learned counsel for the petitioner has however expressed urgency by citing that an auction process is scheduled on 28th, right?
Yes,
28th.
my Lord. Yes.
28, puts the para. Accordingly, let the matter be adjourned to be listed on 26th. 26/6.
Mark.
Okay.
Lord, the connected matter also will be listed along with this. There
Yes,
is
yes,
one
along
connected
with- yes,
matter as well.
Yes.
Deeply, Lord.
Yeah, the connected WPC 156 of 2025 be listed accordingly
Deeply, Lord.
with this case.
Ma'am, please, Lord.
6.
And I beg to
Also,
mention
he-
item 3, my lord, kindly the pass over for a day, my
Which
lord.
one?
Item number 3, my lord.
Sorry, motion matter.
Yes, ma'am. My lord, I have overlooked the cause list, my lord. So
Hmm?
I have overlooked the cause list, my lord.
Okay, okay. Okay, yes.
Item 3.
On a prayer by Sri R. C.K. learned counsel for the petitioners. Matter is adjourned to be listed when? Wednesday?
My lord.
On Wednesday date. Following.
My lord, beg to mention item number 1.
1, yes.
On behalf of N. Taje, leading counsel is out of station.
Why are you mentioning? Okay. A prayer for adjournment has been made on behalf of Sri N. Taze, learned counsel for the petitioner. Yes, government advocate, Mr. Tapin, you are there? Sri S. Tapin, learned senior government advocate, AP is present. On request, list on when?
Yes.
list on Monday, next.
Yes.
First, item number 1.
This matter.
His senior is not there.
He's also on letter of absence.
In that case, Madam, let this be on, since I'm coming on 16th of June for the other. matter.
16th,
16th.
Yeah. As requested, list on 16th. Then you write AG, huh? AG. 16.6, item number 1, 16.6. 1 is along with 2. 2, the councils are there, Mr. Sonar. 1 and 2 together will come on 16th.
May I please, Lordship?
Yes,
May I please, Lordship? Lordship,
Yes.
I am for the informant.
yes.
Today, the learned PP is not present, learned PP. I'm
Who's
for
the
the
PP?
G Tado. I'm the informant. So my humble prayer is, this matter may be kindly list after 1 week.
Madam,
I'm the amicus,
okay, what do you say?
jail appeal.
After a week? Okay. Your Darang,
Yes, SV Dara.
heard Miss S. B. Darang, learned amicus for the appellant. Also heard.
Ex Gatti for informant.
Yati, learned counsel who appears for the informant, who has however paid for some accommodations on behalf of the learned PP, who is absent today. Pusta para. In view of the above, matter is adjourned to be listed when?
After 1 week.
Any fixed date?
Okay, listed for hearing on, today is
Today is 19th.
19th. We'll have it on 27th. Is it okay? 27th. 27/6, Tuesday, next Tuesday.
All right.
27/5, sorry, 27/5, not 6. 27/5.
May I please, Madam? Here, my lord, may I please?
Yes,
Here, my lord, a challenge has been made to the Rule 5 of the, my lord, Arunachal Pradesh Food Security, State Food Security Rules 2020, my lord. Rule 5, my lord, which is not in consonance with the, my lord, Section 17 of the, my lord, National Food Security Act, my lord. My lord, National Food Security Act, Section 17, my lord.
this is for hearing final disposal.
It's just that one thing I must point out, the tenure under the statute is 5 years. That 5 years is over. So unless he has,
But in prayer, I had made in prayer matter for area allowances matter. Because allowances matter.
If the tenure is over, you can, without expressing anything, we can close this at the appropriate time, you can raise it. Because this is mere academic, I think.
it will perhaps become an academic exercise.
You take instructions, otherwise, if you suppose it goes against you, for future also you'll be precluded from raising the issue. Because if during the subsistence of the tenure, you are arguing, the matter would have been different. Now, you take instructions.
My matter.
Okay. Third, 3, R. Secretary, learned counsel for petitioner. That also heard 3, I. Chaudhary, learned AG, AP, who however contends that the tenure concerned is over and the matter has, for all practical purpose, become academic in nature. Para, Risakya, learned counsel for the petitioners at this stage, prays for a week's time to obtain instructions regarding the future course of action. Para, list after a week. Have it on 16th?
16.
Okay. As requested, list after, as requested, list on 16th. Okay, single bench in 5 minutes.
May it please, your lordship.
Yes.
My lord, I seek some accommodation, my lord, only for today. My lord, here
Which
in
one?
Guwahati, and my lord, item 11 and 13. Tonight I am reaching Itanagar, my lord. Tonight
I
itself.
came, Mr. Tiwari has to compensate because I came yesterday.
My lord,
for this matter.
I'll do that.
And
my lord.
today he's enjoying in Guwahati.
My lord,
You
not
don't
enjoying,
enjoy
my lord.
Guwahati,
Mr.
nobody,
Kap-
Mr. Tiwari, let me say
No.
something. Guwahati, nobody can enjoy, but one can enjoy in Arunachal Pradesh.
That's it, my lord. So, my lord, tonight I am reaching, my lord. Only tomorrow, my lord, 11 and 13. Both are for
When do you
admission
want?
hearing.
When do you want?
My lord, tomorrow itself. I'm reaching tonight.
Because there is an interim order which has been passed in the
In both the
paper.
matters you are
here.
there.
Yes, one matter, 11.
Where?
Item number 11.
11 you are there.
Yes.
And 13?
And 13, my lord, I am for the
My lord,
respondent.
I'm for the 13.
Okay.
Petitioner.
13 you are for the respondent.
Yes, my lord, I am for the respondent.
And 11?
11,
I'm
Mr.
appearing for the respondent.
Okay. Sri P.K. Tiwari, Learned Senior Counsel, who appears online, has requested for an accommodation till tomorrow. Sarah, it was item number 11. Go. Government Council, Tapin is there, I think. Who is there?
No, sir.
11. Sri Parmi, the Learned Standing Council power, as well as Sri D. Das, Learned Senior Counsel for the private respondent,
Yes, private is.
are present, who also inform that there is an interim order
Yes.
operating. Accordingly, matter is adjourned till tomorrow, to be listed tomorrow.
Yes.
Interim order passed earlier to continue till the next date of listing. This is 11. Then 13. Three. P.K. Tiwari, Learned Senior Counsel for the respondent,
Yes, my lord, respondent.
private respondent.
Yes, my lord, private
Private
respondent.
respondent has paid for an accommodation till tomorrow, Sarah. In view of the above, matter is adjourned to be listed tomorrow. Okay. Date jiba, huh? Do it. 11, 13. Okay.
My lord, may I mention item number 7?
7 years.
My lord, with the consent of the parties, so I am seeking adjournment for a week, my lord,
For a week.
for a week.
You are for?
I am for petitioner, my lord. As the main counsel is out of his session today.
A prayer has been made on behalf of the petitioner
On behalf of
On the
T.T.
ground.
Tara,
that Sri T.T. Tara, Learned Counsel leading in this case, is
out of his station,
out of station. List after a week.
after a week, my lord.
List after a week.
Grateful, my lord. Interim order may be continued, my lord.
Interim order passed earlier to continue till the next date of listing.
Grateful, my lord.
May I beg to, your lordship, item number 10.
10.
Yes, that may be, I have to file a rejoinder application, 2 weeks, maybe fix after 2 weeks.
On the prayer of Sri T. Tapak, Learned
Tapak.
Counsel for the petitioner, matter is adjourned by 2 weeks to enable him to file rejoinder affidavit.
And one more mention, lordship, item number 17.
17.
Yes, that may be fixed on 19 of June.
19 of June.
Yes.
Item
We
number
will file, we will
17.
file affidavit,
Item number?
19,
Nine-
17, item 17.
Your name, you are not there?
Yes, not here, I am mentioning on behalf of IOCL.
Okay, you are for the IOC?
Yes.
Okay. Sri Tapak, the Learned Counsel appearing for the IOCL, prays for an adjournment. Full stop. As requested, list on 19 June.
Not 19 June.
19 June, you have filed a
19
affidavit.
For filing affidavit.
Requested for an adjournment to enable filing of affidavit in opposition.
Yes.
As requested, list on 19 June to enable filing of such affidavit in opposition.
All right.
Is there any interim order?
No item.
17. Takar Jamo, IOC asset of this one. For the IOC respondent. Huh? Item number?
This is a Motu case. Motu case. Yes. Hearing the case, I have been furnished a copy of the case record, and it is seen that there, in this case, around 15 accused were arrested. And out of that 15, 9% have been granted on bail. So far the record is concerned. Now, this is a case falls under section 6, 8, 12 of the POCTO Act and section 3, 4, 5, 6 of the Immoral Trafficking Prevention Act 1956. Now, the procedure laid down for applications of bail has for that purpose, it becomes a mandatory that whenever a bail application is made or any criminal revision and criminal appeal is made, in such a case, notice should be issued to the victims.
Correct.
But in entirety, in entire case record, it is seen that there is no notice was issued to the victim. Apart from that, initially, 2 persons was granted on interim bail, and it was made absolute. Where the absolute was made, that time, the victim's advocate was not issued notice, as such he was absent, and informant advocate was also absent. Where the informant advocate was absent, the court passing of the making absolutely interim itself become beyond this jurisdiction becomes illegal. Therefore, for the end of justice, that since Gulang Mari have been shown here as a petitioner, this petition shown as petitioner in WPC for reinstatement in service. So while they filed a writ petition for reinstatement of his service, they have endorsed the annexures of bail order. During the bail order, it was found that there was no hearing of the victim, there is no hearing of the informant advocate. In absence of that, how the case, the bail was made absolute? That is the thing. This is the only case that there was no notice was issued to the victims. They may appear, may not appear, but issuing of notice is must as per the Guwahati High Court notification. Apart from that, there is a Supreme Court ruling in Jogjeet Singh and others versus Ashish Mishra alias Manu. Now I'll furnish a copy. This is the copy. Come to the para 14 1 24 1 and 24 2. First, the Indian jurisprudence is constantly evolving, whereby the right of victims to be heard, especially in cases. Paragraph 24(1).
24.1.
Yes, 24(1). 24. Yes, 1.
Yes,
and 24(2). Second,
yes.
where the victims themselves have come forward to participate in a criminal proceeding, they must be accorded with an opportunity of a fair and effective hearing. If the right to file an appeal against acquittal is not accompanied with the right to be heard at the time of deciding a bail application, the same may result in grave miscarriage of justice. Victim certainly cannot be expected to be sitting on the fence and watching the proceeding from afar,
Correct.
especially when they may have legitimate grievances. It is the solemn duty of a court to deliver justice before the memory of an injustice eclipse. Then, apart from this, our High Court has issued the notice, a notification that
After Deepak Nayak. This is
yes,
after Deepak Nayak.
after Deepak Nayak, and Karnataka High Court also given. And here in the notification, it is clearly mentioned that in every such bail application, criminal appeal, criminal revision, criminal petition filed in the High Court, it shall be mandatory to implead the victim's guardian support person, as the case may be. While making such an impleadment, identity of the victim shall be properly strictly adhering to the mandate of Section 33 of subsection 7 of the POCSO Act. Upon impleadment of the victim guardian support person in the bail application, criminal appeal, criminal revision, criminal petition, as the case may be, formal notice shall be issued to the such victim, formal notice, guardian support person
Yes.
through the investigation. So here in the case, there was no notice was issued to the victim. But in spite of that,
Bail was granted.
bail was made obsolete to two accused persons, that is Michi, and then President Bulang Mari. Now, while I seen the record, I have seen that 7 persons have been granted bail on the equal footing. Therefore, since in this case, in this present in red, we are concerning about the bail applications of Malik Bulang Mari. Now, what I have observed, what I have found in the case, it is found that 7 more persons have been arrested, released on bail, apart from the 2 other persons. So, those persons are also to be impleaded, and they should also be issued a notice. Why their bail should not be cancelled? That is the case. Because while the bail was granted to those persons, and we are confining the case is confining to the only Bulang Mari. Now, my content is that for the end of justice, for the same transaction of the case, from same order, same case, then why the others will be escaped?
You're correct.
That is for the end of justice. So a notice may be issued to the other accused person who were released already in bail on the equal footing.
This suo motu proceedings was initiated for what basis? What was the reason of, what is the objective? Why his bail should not be cancelled?
Yes.
Okay, so same footing you want the notice to be issued to the other.
Other accused whom bail was already been granted.
Okay.
That is in
Though the details of those 7 persons are here in the records.
Seven percent will lead to a bail. 7%. Other than this, the ground of granting bail to the other accused was that the victim statement has already been recorded. Recorded. That is the ground of granting the bail.
Okay. The
And I am not going to the,
records of the POXO cases come? Has it come? Yes, it has come.
I am not entered to the merit of that case.
Yes, yes, yes.
Maybe,
Yes.
maybe on the ground is maybe
Yes.
genuine or may not be genuine. But my concern is that
Okay.
while granting the bail,
Yes.
well, the interim order was made.
Who's
also
appearing for this?
notice must be
accused?
issued to the victim.
Anyone appearing for the accused?
I'm appearing for accused Bulang
Yes.
Maring, my lord.
Yes.
My lord, if I may give a quick response to my senior prince argument.
No, but was it, was the victim given a chance of hearing?
Yes, my lord.
Which order? she
Well,
said?
first bail application for interim bail was given, my lord. Notice was given, my lord.
No, notice, was they heard?
Yes,
they
my
come
lord,
before the
the
court?
victim, I mean, the counsel representing the victim was heard.
Where? Say was the order? Mr. Kato?
Malam.
Was the victim heard?
The very effect of the case is, when the bail application was filed, the copy has been duly served to the informant complainant. Now, informant complainant.
Who was the informant?
Informant complainant is the chairman of the child welfare
Okay.
committee. He, C is also the practicing lawyer. The copy has been duly served. If lordship perused the
Okay. Then at the time of consideration of the bail,
C was present, and her counsel was also present, but admittedly in the order sheet it is not reflected,
no, then we'll have to go by the order sheet.
in the admittedly, the all were known that
No, that would, so we are in a court proceeding. We cannot go by knowledge.
Yes, ma'am.
We'll go by court proceedings.
Yes.
If the proceeding
Admittedly, that
has not
that-
recorded that she was heard, then it's not in accordance with law.
Yes, admittedly. Thereafter, what happened in the subsequent bail hearing, when the extension was given, at that relevant point of time also, the copy was served. And in some orders, if lordship perused my additional affidavit, in some order, counsel of the informant complainant has been reflected, name of the complainant. They were also heard. And in order, on the same day, some mistake has been admittedly, maybe the failed to record the name of the counsel for the informant complainant. But in some order, admittedly, there are so many orders. Very
No, we cannot take a chance of offense of this nature. If the law requires that the victims should be given a hearing, to the extent that if the victims are unable to defend themselves, then the court will appoint an amicus curiae. Even Deepak Nayak, the last, I think number 4 also says that first issuance of notice is mandatory.
Right.
And not only to the if the victim are not their guardian or even the body who is taking after care of them. And if they are not in a position to appear, then it is the duty of the court that you have to appoint an amicus curiae. Victim cannot go unrepresented. Yeah. Now, if the order sheet does not reflect that the victim was represented, then this order will be non-est in law.
No
other-
victim was
No
represented.
other option. We are not on making any comments on the merits. On merits,
SB Darang represented
Mr.
the
Kato,
informant.
you may agree,
Informant.
being the PP, on merits, a case may be made out by the victim, by the accused for grant of bail. That is absolutely on merits, but this is on the procedural part. First, we'll see whether the procedure is followed or not. Now, Mr. Patil has said something very important, that along with this person who is before us today, there are 8 other persons.
Nine persons have been.
Total 9,
Nine.
he has come, so 8 will be remaining, isn't it?
My lord, exactly what happened, my lord. My lord, bail was made actually after the recording of the victim's statement, my lord. The court was of the opinion that, my lord, once the statements of the victims, all the victims.
No, we are not on that.
My lord, thereafter.
We are not on that.
Actually-
Recording of the victim after recording of the depositions, we are not on that. We are on the aspect of legal assistance to the victim.
My lord. If my-
Whether legal assistance is given. See, 164, 161 statement, even a deposition in the court in the dock. If they are not represented, you are not having the legal aid.
My lord, may I read the order of the 4th January?
Now, are you supporting the victim or are you supporting the cause of the case? As a PP, you have to make your position very clear.
True, my lord. That I.
I'm for statement.
My lord.
Oh, you're for the accused
Yes.
person.
I'm admitted to that extent, my lord, that in some order, my lord, the name of the counsel for the matter.
We thought you were appearing for the state.
My lord.
We thought you were appearing for the state.
I'm sorry. Since lordship asked me this, my lord,
No, you stood up. We thought that you are for the state.
Sir, my lord.
You are for 2 of the accused persons.
Yes.
2, one
Yes.
by Master Abha, one by Kato.
Yes.
Yes, they are for the same person. or what? How many accused are there?
Only one.
No. Total.
Nine.
Nine.
Altogether, 9.
So we'll include the other 8 also. This is an important matter. Cannot be
See the
left like this.
procedural lapses, my lord. And this, for this, my lord, procedural
Mr. Abha,
lapses.
please
Hmm.
get it clear from us. If you are entitled to bail on merits, we have nothing to say. The discretion of the court, if it is exercised after following the procedure in granting bail, we have nothing to say. Unless that is a gross exercise, the gross error,
I
which
have
is apparent on the face. Otherwise, we hardly interfere with granting of bail. It's an exercise of discretion.
I
But if you
understand.
exercise discretion, it has to be done with us by taking due care and attention. That is what we need.
If summons have not been issued, my lord, this is also a fault of the, my lord, presiding judge of the land.
That is why the suo motu proceedings have, we are not finding fault on you
And
at this
For
point
that,
of
my
time.
lord, my client cannot be attributed to.
No, you are the beneficiary of an illegal act.
Yes, my lord.
You have to face the consequence. We are not saying that you will not be entitled to pray for a regular bail in accordance with law. You pray for bail, give the victim an opportunity of hearing. Hear them. If they are not ready, appoint an amicus. How do you pass an order of bail without hearing the victim? And issuance of notice is not a mechanical process. That is what time and again we have been repeating. Jadid Singh, then Deepak Nath, that notification of 17. And if you see clause number 4, I think it's a specific, there is a provision to appoint an amicus, even if they are not in a position to appear. Why is that clause? In other civil matters, notice is gone. If you choose not to appear, we proceed.
The fact that, my lord, the chairperson of the CWC was all along representing the
No,
victims.
her name is not reflected, but Mr. Kato has said. Somehow maybe due to inadvertence or something, but it's not there. If it's not there, it's not there.
For that, my lord, I cannot be attributed to, my lord.
No, but you have to go by the process established by law.
In that case, my lord, I should not be prejudiced, my lord, at this.
What is the prejudice? You have you have got the benefit of an illegality. You have to face the consequence. There is no other option. Some illegality has taken place. I said, no, I was not having any role, but I'm a beneficiary.
That's what I said.
We implement the other 8. Please give the details. Here for Mr. Parling for. Okay, yeah.
2025.
Of this code.
No, my lord, of the trial court.
Okay. Okay, 20. What has happened then?
The difference 20.
Okay.
So you know how the other.
But the others have not, others have also got bail.
Yes, ma'am.
All
All. Whether notice of this, the witness indicated there is no need.
But from the records,
The records are not revealed. The only revealed is that.
All accused are on bail, ma'am.
Mr. Patil,
Yeah.
apart from this person, there are 19 other persons.
Here in the order dated 18/1/2025, particularly in para 6, I have heard all the learned counsel appearing for the parties and also carefully perused the case record and taking into considering the fact that victims are already examined by this court as production witnesses.
For the time being, let us issue notice to the remaining 7 persons. And we'll also call for the record regarding the rest persons out of 20, whether the victims were given an opportunity of hearing, whether they were heard or not. Not only whether they were heard or not.
Yes.
Okay, then we'll decide, okay?
This court is inclined to grant bail to accused person, namely Debiatara, Senlar Ronya, Nilam Mangha, Jomlo Tagu, Rido Nime, Bamang Moses, on execution of a bail bond of 50,000 each. So this is the order which was passed on 18/1/2025 on the same footing. Now they are only confusing.
Yes.
What is their informant and victim? Issuing of informant
Yes.
notice to the informant will not cover up the notice issued to the victim. Victim is different and informant is different. So they cannot make any dispute that they never issued any notice to the victim. May come, may not come. In the entirety of the case.
Okay,
My lord, with due respect, my lord, if I may make a proposition, my lord. My lord, can this be remanded back to the presiding judge, my lord?
Why? If we see that the bail has not been granted in accordance with law, we cancel the bail.
If
And you have the opportunity to approach the court.
opportunity is not given, this is the
No, you
allegation.
can file, no, while cancelling, we'll only record the reason of not giving an opportunity. You cannot remain at large, taking the benefit of an illegal order. You have to be brought in custody, then you pray for bail.
Mistake is on the part of the presiding judge, my lord.
That is why the suo motu proceedings have been taken. And it came to light only because of filing of WPC 195 of 2025. Okay. A very serious issue had confronted this court while taking up the connected WPC 195 AP of 2025. Full stop. The said writ petition was filed for, what was the cause of action? For reinstatement by the petitioner on the strength of reinstatement of petition. The petitioner in that writ petition appears to have been suspended pursuant to his arrest in Oxo. In what is the case number? In Itanagar. Women Police Station case number 20 of 2024 involving, amongst others, the POCSO Act and the Immoral Trafficking within bracket Prevention Act 1956. Full stop. While considering the said petition, this court had noticed that the order of bail which was passed by the learned trial court did not reflect that the victims were in fact heard. Accordingly, the present suo motu proceeding was directed to be initiated, which was taken up on 9/5/2025. Para. On the said date, this court had passed an elaborate order touching upon the facts of the case and also discussed the guidelines passed by this court in notification number 17 dated 15/3/2024, which was in accordance with an order dated 23/6/2023 passed by this court in criminal appeal J number 40 of 2022 within bracket Deepak Nayak versus State of Assam and others. Full stop. Accordingly, notice was issued as to why the bail should not be cancelled. Full stop. Para. In today's proceeding, Sri M. Patil, Learned Senior Counsel and Standing Counsel of the High Court, has assisted this court by contending that from a perusal of the records, the aspect of hearing the victim, which is mandatory in nature, was not followed. Full stop. He has, however, informed that apart from the present incumbent, there are 8 other incumbents. 8 others. No, you said 9 were granted bail. 15 persons arrested, 9 were granted bail, you have said.
Misi Tobin and the Bulang Marit, they were granted, they have been granted interim bail, and later on it was absolute.
No, total 9%, isn't it?
And after that, as per the 6, 1, 2, 3, 4, 5, 6 persons, they have granted on the same day, that is on 18.
No, what about those persons who were granted interim and then made absolute? What about those persons? 2 persons.
2 persons.
They are here or not?
No.
One is here, so 1 is remaining, and the other, the rest, how many?
There are total 28 persons. So the record, as far as record will be furnished, we are not ever.
No, we told you in the beginning. So far as the others are concerned, we will ask for a report from the concerned judge whether this was followed or not. Now, at present, notice, apart from this person who is represented by Mr. Kato, how many else?
Only one. One is to go to Michita.
Only one.
Yes.
And the others?
Others, they have been granted by different order. I don't think.
No, Mr. Martin is saying same procedure by following this order only.
Michi Tamin was granted interim bail, and later on it was.
Please give a list of the persons who, other than the present incumbent, please give a list.
Other incumbent.
You can, Mr. Patin, you can ask your assisting counsel to give a list.
Deviatara.
No, please give a list.
Senya Ronya, Nilam Mangha, Jomlo Tagu, Rido Nime, Bamang Moses. These are the as per the order dated on 18/1/2025.
There are others. who have got a similar benefit that, and their names are as follows. But notice will go.
This is the order has been passed on the same date, but it's a different order.
Understood, but let us, whether it was reflected or not, notice was issued.
Madam, just a moment, madam. The informant as well as the learned counsel is found absent without steps. Though trial of the case is fixed today for examination of witnesses. It is what is required.
কি করলো হ্যাঁ? কি হয়েছে তার উপর কিনে? উপর জোরাট করা উপর কিনে? There are others who were granted bail by order dated
18/1/2025.
18/1/2025 by the learned trial court.
These are bail application numbers 03, 25, 41, 42.
No, don't say. Please, can you give a list or you can give that copy of the order? It's there, I think, in the records.
Must be, my lord. Must be, my lord. I can pass it.
To the following, by bail order dated 18/1/2025, the names of whom are
Yes.
given below. Please give the names. Okay,
my lord.
given below. What about the addresses?
It's not,
Addresses will be in the records.
it's not reflected in the
No,
order
it is in
sheet.
the records.
Yes.
It will be in the records.
Fine.
I think submission to case report. What you know? No, but last chapter. He accordingly submits that notice for cancellation of bail is also required to be issued to the other accused persons. Full stop. Sarah? You are appearing for both the, whose name should we record?
I'm in present, Bolang Mari.
Kato for
Same.
Sri S.R. Radha, learned counsel who has appeared for the accused, has however submitted that his client did not have any role in the procedure which was to be followed, and bail was granted to him in accordance with law, which is not liable to be cancelled. Full stop. He has also submitted that no fault can be attributed to his client for the bail granted to him by the learned trial court. Full stop. Para. Sri T.A. learned PP, additional PP, AP has submitted that following of the guidelines passed by the High Court after the case of Deepak Nayak is mandatory in nature, as the objective is to give the victim not only an opportunity but an effective hearing for before passing any orders concerning any orders in application, public appeal filed by the accused persons involving the POXO Act. Para, Sri Pangin, the learned amicus who has been appointed to appear on behalf of the victim, has however submitted that apart from the names which have been given by the learned senior counsel for the High Court, it appears that in total there are 20 accused persons who were granted bail, and similar procedure is also required to be taken against them. Para? Considering the above, let notice be issued to the persons whose name has been reflected in paragraph so and so above, paragraph number 81. The addresses of the persons are to be obtained from the records of the case which have been transmitted to this court by the registry. The address of the persons are to be obtained by the registry from the records of the case which have been transmitted to this court. Full stop. The learned trial court is also required to transmit the copies of the bail orders for the rest of the accused persons to examine as to whether the procedure laid down in the notification 17 dated so and so was followed to to pass further orders, to enable this court to pass further orders. List on, yes, when? List on,
I don't know, this has to be either issued through PP or office of PP or my lord, through a special court.
it is to go to, the,
Office of PP.
not to the victim, it is to the accused person, not PP.
Through, yes, your lordship, through, my lord, through, maybe through a special court, your lordship.
Yes, for registry for the revision, the notices to the aforesaid persons are to be transmitted through the learned special court.
Yes.
Yes, when do we fix this case? Next week, will it be served?
Should be a order from
No, the accused persons.
the accused person. So,
We'll have it 2 weeks. List this, we'll give a date, important matter. List this case on today's on 3rd of June. 3rd of June.
I will give the names.
Yes, sir, please give the names today.
There will be eight.
Yes.
Yeah, obliged.
Welcome to town receipt. Mr. Martin, you can take this back and give, hand over on the next date. The Jagjeet Singh and the notification.
In this case, on the last occasion, sometime provided to me to file an additional affidavit to file some additional documents. The records has come. I may be given just 1 day time. We can take it up day after tomorrow. I'll file it tomorrow.
Okay. Preeti Patil, Learned Counsel for the petitioner, prays for some time to file the additional affidavit, which was directed earlier by this court. Para? Also heard Ms. Basar, Learned State Counsel, who does not object to the said prayer. Para? In view of the above, list this case
22nd?
on
22nd?
22nd.
19.
Will you be able to do it? 22nd?
Yes, well, only in the record, I have to just
Okay,
make
on 22nd, by which time the rejoinder affidavit, the additional affidavit is required to be filed.
Malad.
Okay.
Obliged.
May I please, my lord? Here, my lord, I am challenging the, my lord, constitution of my lord, Digaro Reserve Forest by a notification dated 6/4/1998, my lord, without following the, my lord, due procedure of law, that is, my lord, in violations of the Assam Forest Regulation 1891, my lord. On the last date, my lord, on 8/5/2025, my lord,
Yes.
the Honorable Court directed me to convince this court that, my lord, there is no delay in challenging the, my lord, the constitution of the reserve forest, my lord. My lord, my humble submission is that, my lord, this, my lord, came to light only after disposal of the one writ petition, my lord, in a, my lord, land acquisition proceeding, my lord, which was initiated in the year 2018, my lord, for construction of double laning of the national highway, my lord, and for which, my lord, finally a land acquisition notification was issued in the year 2021, my lord.
You have filed affidavit.
No, my lord, it is in motion stage, my
You have to
lord.
file affidavit.
Yes, my
27 years delay is not a substantial, is not a, it's a substantial delay.
lord, because, my lord,
You
I
file
will,
an additional affidavit.
my lord, I will rely on the, my lord,
Yeah, you
case,
put
my
on
lord.
affidavit.
Yeah.
This, see, writ petition are not governed by the Limitation Act, but the aspect of laches is always there. So if not an application, an affidavit would be required, if you have not explained in the petition itself.
And I have explained these things in the
Petition?
Yes, petition, my lord.
Where,
My lord, the paragraph, my lord, 13, my lord,
1-3.
1-3, my lord. For the first time, my lord, we came to the knowledge, my lord. May I read, my lord?
Yes, please.
Page 13. That it is to state here that in compliance. Page 22, my lord.
22, yes. Yes.
May I read, my lord? That it is to state herein that in compliance of the honorable court's order dated 13/10/2023 passing WBC 514 of 2023, the Deputy Commissioner Tejur, Lohit District, disposed of the representation dated 3/2/2023 submitted by the petitioner by order number dated 4/12/2023 on the ground that the status of the land being reserved forest and the land acquisition notification has already been denotified by the state government. Therefore, question of granting ownership or
Okay,
granting. of-
okay, we'll do one thing. We'll issue notice,
Yes,
but we are not expressing any opinion on the aspect of laches. We'll say prima facie, we are of the opinion that this needs to be, notice needs to be issued, but you can take up the point of laches. Here for whom? The state.
State, my lord, yes.
Okay.
My lord, they are challenging the notification 1971.
Yes.
Now we are in
That
2025.
is it. that will-
54 years, my lord.
The subsequent notification
Okay,
annexing another area, my lord, in
Okay,
1998.
3 R Sakya, learned counsel for the petitioners who has put to challenge the petitioners have approached this court in representative capacity for the villagers of Paya village in the district of Alu,
No, my lord.
No.
Lohit, my lord.
Lohit district.
Lohit district. Full stop. The petitioner has put to challenge a notification dated 8/6/7071, whereby the petitioner's community land was declared as reserve forest. And full stop. The petitioners have also challenged subsequent notification dated 6/4/1998, enlarging the earlier area from 184 square kilometer to TO2 204.45 square kilometers. Full stop. The petitioner alleges violation of the AFR 1891 and also the principles of natural justice. Para. This court, while taking up this matter on 8/5, or what?
8/5.
8/5. On 5/5/2025, as well as 8/5. No, 5/5, not 8/5, 5/5. 5/5/2025 had, however, noticed the huge delay in approaching the court and had accordingly granted time to the learned counsel for the petitioners to explain their position. Please have your seat, don't stand like this, sit. Para. 3. Sakya, the learned counsel for the petitioners, have drawn the attention of this court to the averments made in paragraph 13 of the petition.
13,
By which-
14 and 15, my lord.
13, 14, and 15 of the petition, and has attempted to explain the delay. Full stop, para. On the other hand, Sri R.H. Nabam, the learned AAG, Arunachal Pradesh, has strenuously opposed the writ petition and even the maintainability thereof, as the same has been instituted after a gap of almost
54 years.
after more than 50 years. Full stop. He has also submitted that the explanations set forth are not at all convincing. Full stop, para. This court has perused the averments made in paragraphs 13, 14, and 15 of the writ petition. Full stop, para. After perusing of the same, comma, this court is of the opinion that notice may be, notice is liable to be issued, which is accordingly done. Full stop. Let such notice be, and that the aforesaid notice is made returnable by 6 weeks. Year for 1 to 7.
1 to 7, right?
Sri R.H. Nabam, the learned age, accepts notice on behalf of respondent numbers 1 to 7. Union of India,
Yes, my lord. On behalf of M. Khatam, my lord.
Sri so-and-so
For
learned
respondent number
counsel accepts notice on behalf of Sri M. Kato, learned deputy SGI for the respondent number 8. Para, let extra copies of the petition be served upon the learned counsel for the respondents within 2 days. Para, since the notice has been issued on a prior view of the said of the aforesaid averments, made in paragraphs 13, 14, and 15, comma, the aspect of maintainability on the ground of latches would still be kept open. Would still remain open.
But on that day, my lord,
But is kept open.
my lord, on that day, let the state be file affidavit, my lord.
Will fine. Returnable date was set.
6 weeks, matlab, probably the house soon will give us extra copies. matlab.
By 2 days we have
2
set.
days.
Yes,
May I please, my lord?
item number
5, my lord.
yes, please.
My lord, here in this case, the petitioner or the judgment debtor, due to in the consumer case number 11 of 2020 in the district forum. Thereafter, within the period of limitation, we filed our appeal in the state forum.
Okay.
In the meantime, the decree holder filed their execution petition, and here is the annexure 1 is the impugn order, where execution order dated 23/2025. We were directed to pay the decree money. So, my lord, while the pendency of the appeal, we learned that State Consumer Forum is not sitting for the last 2.5 years due to the non-appointment of the president. So now, my lord, we are before this honorable court for the stay of the execution order, and that is the case. So we are caught up in a very peculiar situation, my lord. We cannot go to the National Consumer Forum also, and there's no other such forum except for the state forum. So
What case law? Are you relying on certain case laws? In a matter of this nature, in a situation of this nature, can you come to a writ court? If you can come, what remedies are available? Tell us.
That legal maxim that an act of court should not prejudice.
No, we have case laws
My lord.
directly on this kind of a situation. The court or the tribunal is not there, not functioning, lack of the presiding officer for months together, years. Can you be left remediless? If you cannot, can you come to the writ court? What is the proposition? Where are the case laws? You have to come prepared. Come prepared tomorrow. Okay? On the prayer of, we are not ousting you from the jurisdiction, otherwise litigation is not continuable, but situation of this kind, you make some research, there are case laws. On the prayer of H.K. Jamu, the matter is adjourned to be listed tomorrow for motion. Come prepared.
My lord.
May I please, your lordship? And on
Yes.
behalf of the petitioner side,
Yes.
the last occasions, the order was clear that today first heard for the maintainability of the case. So as part the respondents have any question about the maintainability, then I part of my submission at present.
My lord, due to some personal difficulties, M. Kato is leave the premises, my lord.
Kato?
Oh.
Yes, my lord.
We'll have it when, day after tomorrow?
Yes, my lord.
Oh,
Your Honor, if possible, I give some another date
yes.
so that I can convene to. Your Honor, if possible, May fix on 22 of this month.
5th May,
No,
25th,
22 of this month.
22nd.
After 2 days.
22nd is okay. Then you can have it on 2nd of June.
Okay, my lord.
2nd June,
Yes, madam.
Mr. Council.
Two second, Your Honor.
2nd, 3rd, whenever.
Okay, my lord, 2nd June.
2nd June.
No, no.
Okay.
If he ready,
While
then I have no
the
issue.
petitioner is represented, a prayer for adjournment has been made on behalf of 3M Kato, the Deputy HGA. Pustapara. Considering the same, the matter is adjourned to be listed on 2nd of June.
2nd of June, Your Honor. Much obliged. Deplore.
Item number 89.
Private matter. Item number 8. Work is also almost 80% complete, and they have now withdrawn the EMD.
Yes, yes. Instructions.
My instruction is that the EMD can be deposited at any time, the item number 8, because the huge amount that cannot be kept idle, that's what my client says, because that has to be used in other tenders also. It can be, but depending upon
So you
the
are
case.
66 lakhs is.
Yes, my lord.
That withdrawal, that will not foreclose his right to hesitate. But what about the completion of the work? Will you gain substantially? We can, at best, we can, if you are successful, number one, in making out a case, then we can say that you can approach the civil court for damages.
They can
But-
do in any case.
Even
But
financial
if-
bids.
But if we say anything which is against you, then even that road will be closed.
But not in the other case, second
Yes.
case, no, it is not. In the first.
Second
eight,
case, madam, I am- For this, madam, for
Second
the second
also-
case of the last occasion,
Yes.
on the last occasion, your lordship called for some instruction from the state council, madam.
Yes, I have recalled.
You come to a consensus, how do you proceed with these two matters?
The first matter is Mr. Pangin's different matter. Of course, in that case, I admit.
Almost complete. EMD also.
Withdrawn.
First matter, you tell us whether you like to pursue the first matter, second matter, both the matters, or pursue none.
Second matter, definitely I would.
Okay, then
First.
first we'll adjourn, or first, should we close without expressing any opinion on the merits? We close the first one.
Yes.
First one is item number 617.
8.
Huh?
Yes. 617.
Third,
Item number 8.
repeat of learned counsel for the petitioner. Also heard Sri G. Tarak, learned standing counsel RWD for the official respondents, whereas Sri D. Pangi has appeared for the respond numbers 5 and 6. 6. Full stop. Para. The writ petition was instituted challenging the tender process pertaining to an NIT dated 3/7/2024 for construction of synopsis. The said process had culminated in the award made in favor of private respondents. Full stop. Though pleadings have been exchanged in this case, Sri Kanging, the learned counsel for the private respondent number 6, has informed this court that more than 90% of the work has been completed in the meantime. The aforesaid submission is also endorsed by the learned standing counsel of the department. At this stage, Sri Tafu, the learned counsel for the petitioner, has submitted that being the situation, he would not like to continue further with this petition. However, he prays for a liberty that However, he clarifies that he is not withdrawing the challenge on merits. Tara? After considering the aforesaid submission and being informed that more than 90% of the work in question has been completed.
And EMD also withdrawn.
उसके ऊपर एक लिखना है ऊपर. The understanding council has also informed that the EMD of rupees 66,91,000 has also been returned to the petitioner. Last one. Last what did you write? Completed. Coupled with the fact that the EMD has been refunded, the adjudication process in this case would be mere academic in nature. Accordingly, this court is of the opinion that without expressing any is of the view that without expressing any opinion on the merits of the challenge and the opposition made by the respondents, this writ petition is liable to be closed, which is accordingly done.
May it please your lordship.
The communication dated 10/2/2025 regarding refund of the EMD is made part of the records. Yes. Yes, Mr.
My lord, your lordship has already called for the record. Your lordship will see what the ground of rejection. I want to make only one submission. Your lordship will peruse the records, my lord. Before that, just I am making one submission. The plea taken by the petitioner is that the same set of documents has been accepted in respect of different work, but the same set of documents have not been accepted for the present work. My lord, that is not the true state of affair. What has happened here is he has submitted same set of documents, like same technical personnel, same machineries for 3 different packages. He has submitted bid for 3 different packages. Now, supposing he gets all work in respect of all the 3 packages, same set of person cannot go to 3 places. Same set of documents cannot be deployed in 3 different places. Secondly, my lord,
it is only copies. Why? Copies why not?
My lord, copy, no, my lord. Supposing he gets the work in respect of all the 3 packages, he will have to deploy 3 different sets of documents, 3 different sets of technical persons, engineers in 3 different places. He has given only 1 set. So that is why the authority has possibly, my lord, I am told the authority has rejected on the ground that there will be shortage of machineries and shortage of technical persons. This is one. Secondly, my lord, subsequently when he submitted bid with these documents in respect of 1 package, then it was accepted. It is correct. Decision of the authority is absolutely correct. Subsequently, when he submitted a bid with these documents in respect of, when he submitted bid in respect of only 1 package, it was accepted. The authority was absolutely right, my lord. So I leave it to your lordship. My lordship will peruse the record. If this is the case, my lord, possibly no case is made out by the petitioner, my lord. And as far as the work is concerned, art cutting in respect of more than 80%, I have been told by my learned junior present there, Mr. Pankaj Bora and another learned junior, that more than 80% of art cutting is already over. And he has taken a very technical plea. Your lordship is well aware of that Roanoke International case where the person, he himself is not qualified. And so far as his disqualification is concerned, my lord, in this case, petitioner has said nothing except saying that I have submitted all the documents. So he is accepting that he is disqualified. If he is not qualified, then he cannot raise objection in respect of others, my lord. Your lordship is aware of the Roanoke International judgment. I'll quote a few paragraphs after your lordship peruses the record, my lord. Lordship may kindly examine the record to be produced by my learned counsel.
The documents which you are referring to, Mr. Mazumdar,
my lord,
these documents were also involving some personnel who would be deputed to the work site.
No,
is it correct?
My lord, authority has rejected, I am told, that
No,
for
we have understood what you are trying to communicate.
my lord, my lord.
The sets of documents pertains to only machineries or personnel also? Who
Both,
have to-
both, both.
Personnels were named. Were they named?
My lord, yes, my lord,
Yes,
personal
name.
name.
Named. So
Yes.
you are contending that how the same person,
Yes,
if
my
they
lord.
are, if those kind of person with those qualification are required as a part of the package,
In three
how
different
would the same
places.
persons be
Can-
available in two
My lord.
places?
If
So
it is
far-
granted,
Now, why
if it
we
is
are
not-
asked this, why we have asked this question
my
is
lord,
if the personnel were not named, then he may have
Named,
number
my
of
lord.
person. But that is
No,
one,
my
but
lord,
so far
named.
as so far as the equipments are concerned, machineries are concerned, he
My
may
lord.
have a duplicate set of or triplicate set of equipments.
my lord, that is why he is not saying that he's got duplicate or triplicate. He is saying only one set of document. That is why the authority said that there will be shortage of machineries and shortage of technical person.
I'll
And
explain
lordship
it
will-
better.
Okay, we here, Mr. Tafu will
Yes.
come to you, Mr. Muzumdar will remember
My
your
lord,
point.
yes, my lord.
My lord, the tender.
My lord may examine the records to be produced, my lord. On one ground they have rejected. Your lordship had already called for that record, my lord. On one ground it was rejected.
First, let us hear, Mr. Tafu, what is the case
My lord.
about? We hear you, what is the case
Yes,
about,
madam.
then we examine the records.
Yes,
And if you can cut short your argument, if
yes,
that is the-
definitely, I'll cut
if
short.
that is the point where which
I'll
Mr.
not make it lengthy, madam.
Majumdar is trying to urge,
Definitely, madam.
we examine the records, then we take a call.
Definitely.
Yes.
My lord, this tender lordship starts from page 37, my lord. My God, this is for name of the tender, my lord.
37.
Page 37. My lord, ma'am, kindly mark the date of tender is 5/7/2024.
Yes.
So, my lord, I participated in the tender evaluation, my lord, board that rejected my bid, my lord.
In technical evaluation.
Yes. And that is page 121, my lord.
121.
Yes, ma'am.
One 21.
Yes. The operative portion is page, my lord, 122, my lord. It's done on the 2nd August 2024.
Yes.
My lord, page 122. Serial number 4, my lord.
Yes.
So, the reason is, my lord, non-responsive, attracts clause such and such, my lord, 4.4B, capital B, small b, I, my lord. 4.4 capital B, small b, 2, and 4.7 I, my lord.
Yes.
My lord, may I kindly see the 4.1, my lord.
Where is it?
My lord, is in the SBD, my lord.
Page?
Page 42, my lord.
42.
Yes. Seven. Yeah, no. 4.4 capital B, my lord. Last paragraph. And small b, my lord. This is small b only, man. And first is small Roman 1. Here it is availability for construction work, either own or lease or hire of key equipments stated in appendix to ITB, including equipments required for establishing field laboratory
to perform mandatory tests and those stated in appendix to ITB, madam. So the appendix to ITB is page 56, madam.
Yes.
Down below, madam, make a 4.4 is quoted, madam, capital B, small b, I. Madam. Here is, first is equipments, madam. Madam, the what kind of machineries are required? This is given in this appendix 4.4B, madam. Truck mounted water tanker, 2 numbers, madam, all those items, it will be, madam, up to page 58, madam. These were the required machineries.
Yes.
Yes. So, and 4. Madam, we see 2, madam. Page 43, madam. Small Roman 2.
Yes.
This availability for construction work technical personnel is stated in ITB. This is also technical persons that's required, madam. That's there, madam, page 59, madam. These are the technical persons required. Lordship got, madam.
59.
Yes.
Minute, please. B2.
Yes, ma'am. Small b2. Side in charge. Assistant side in charge, all those things, ma'am.
Yes.
Yeah, these were required. And last disqualified ground is, my lord, 4.7. Yes.
Yes.
4.7, my lord, page 44. Page 44.
44.
Yes.
Yes.
So, madam, what this says, even though the bidders, I'll read, madam. Even though the bidders meet the above qualifying criteria, they are subject to be disqualified if they have made misleading or false representation in forms, statements, affidavit, attachments, submitted in proof of qualification, requirement, or of record of poor performance, such as abandoning work, not properly completing the contract, in order delays in completion, litigation history, or financial failure, etc., or participated in previous bidding for same work and had quoted unreasonably high or low price and could not furnish rational justification for it to the employer. Madam, the reasons that were assigned in the technical bid was totally ambiguous, madam. For it never specified for what reasons it has been disqualified. It simply quotes the paragraph clauses only. Madam. It's totally ambiguous. It can be, madam, 4.7 can be interpreted in any manner. But in my affidavit, my lord, I have, Lordship, this is the thing that your Lordship will be comparing in the second, my lord, records that has been called for, my lord.
Yes.
Well, page 124, Lordship, it starts, the voluminous, my lord.
Your list.
Yes, list. These are the list along with the annexures, my lord.
These are your documents.
Yes, my documents I uploaded in the website pertaining to this work saying that these are the equipments which I have, madam. Because we have to only submit the documents, madam, not machinery in the site. So these are the documents, and I have submitted personal manpower, site engineers and all that also in this petition, madam. That I have. It starts from, my lord. I'll not read entire, my lord. It starts from page 245.
245.
Yes.
What are these?
These are technical persons, my lord, which I have to be deployed if I'm awarded the work.
Yes.
I'm showing lots of important parts on it, or there are many allegations, counter allegations, all those are there. I will come to that, Mark. Then Lordship may kindly come to page 320, madam.
320.
Yes, 320.
Yes, what is this? 28th of October?
Yes, 28th of October 2024. Well, this is the bit where I have been declared qualified. This may can you see a road from Malad from Savavenia road to Yakli via Diam.
Yes.
Malad, I'll just below the second Malad, I will just want to read Malad. The e-procurement Malad, second number. Malad, just after that name of it. The e-procurement notice was published on 6/7/2024, Malad. This date may kindly be marked. 6/7/2024. And deadline date time for submission of this through e-procurement specified on 23/7/2024 up to 16 hours. Dates published the NIT original are as follows. Can you see, Malad? Notice inviting tender, man. First one. 5/7/2024, man. The exact date which the present tender was floated. The present litigation, man.
Yes.
So, Malad, both the tenders were floated on the same date, Malad. So I would submit the same documents, Malad, machineries which I have, Malad, at that point of time, and same technical personnel which I have, Malad. I have submitted ditto in the both the tenders, Malad. Now the government affidavit, Malad, has not denied the fact that the documents in the both the tenders are same, Malad. That category statement has not been denied in government affidavit. Now government affidavit, Malad, says
yes.
First ground, Malad, behind my back, the respondent authority, more particularly the Malad, superintendent engineer, Malad, alleges that he made some correspondence regarding the machineries and all that to a particular company, my lord. And that company said that the invoice which have been submitted are not genuine. This was the one of the grounds.
Yes.
And I have categorically stated in my writ petition that this was never informed to me. And next ground is that I have not disclosed the litigation.
Which litigation?
Because we have to declare whether any there is the litigation or not one. Pending litigation or not.
You had a pending litigation.
But yes, of course, I declare as per this matter, we have matter.
Which one? The other one?
No.
Which has been disposed of today?
No.
That is other,
Other
in other.
Some other litigation.
Yes.
you had.
Division, yes.
That was not disclosed.
Other division matter, yes.
Not disclosed.
But you had a litigation.
Yes.
Which was not disclosed.
Yes.
Okay.
And in my writ petition, in para 24, I have categorically stated, in the case of respondent number 5 also, the litigations were pending matter. In the High Court matter, I have annexed the order also of this court. In that case, Malad, this simply is that it happens, Malad, in a firm, Malad, litigations due to oversight. It's not a Malad that it should be disqualified. This is a minor defect, Malad. So, but the respondent authority said, in that case, he is the respondent. When he is not petitioner, why he should disclose? In case, because I am petitioner, I should disclose, Malad. That's not the case. The thing is that there is, if whether the department asks whether there's any litigation or not. That is the main allegation of the government matter. In the writ petition matter, I have shown the respondent number 5 matter. The bank guarantee, the documents which they have annexed uploaded in the website. That is for some other project matter, not for this one.
Respondent number
5 matter.
Bank guarantee.
No, showing that the
Bank guarantee is for other purpose, other project.
No, showing that the bank gives a certificate that we can credit facilities of 5 crore matter. That is mandatory in the bid matter.
Is for some other work.
Yes.
Page.
Matter, that category statement we have made in para 13 matter. Page 11.
What is the answer?
Matter,
answer.
This was the document which was uploaded in the website, matter. Because
no, have you given the document?
Yes, we have.
Where? Page.
Matter, Annex 7 matter.
Page.
Matter, just. 268 month. Malad mechanism. This is to certify that MS Tenzing Construction proper such and such a reputed company with a good financial year. If the contract work for, namely, construct a road from Dirang to Jimthung, 7 kilometers, is awarded to the above firm, we shall.
Question.
No. This is totally different one. Dirang is different district also, my lord.
And what is the name of this work?
This is construction road in East Coming district.
East Coming.
Yeah, this is in West Coming district, Jim Thung. Now government comes with an affidavit saying that the bank manager has, particular bank manager has some other date. This was uploaded in the website because website, my lord, everybody's, the documents we can see, my lord. We could see only this document. Now the department comes and say there was another document.
How could this document enter the records?
My lord, they know.
My lord, we have another document. They have annexed another.
No,
The record
we can
which is with us in 17/7/2024. They are recorded 2023 records, documents.
My lord, we can download what's there in the website, my lord. We cannot add also. This is that the document which was uploaded in the website.
But Mr. Tafo, there will be one question.
Yes.
This NIT is of 5/7/2024.
Yes.
They could not have downloaded or uploaded a document of bank
No.
of 2023.
No, my lord. This is a document they uploaded.
Now, how will it be relevant?
My lord, there is a clause.
No, you may be correct that whatever you have found in the uploaded site, you have given it.
Yes.
But with this document is otherwise also, apart from the it being for another work.
Yes.
Even the date is of October 23.
Yes. No, my lord, what the condition of the tender was that there should be a certificate from the bank saying that we can provide credit facilities of 5 crore if the work is awarded. So in this.
So that has to be post the date of the NIT.
No, while filing, my lord, while uploading the documents, my lord, that has to be uploaded together with the document in the website. So this was the document uploaded by the respondent number 5. Saying, my lord, then it fulfills the condition, my lord. The bank is ready to give credit facilities of this much.
Yes.
My lord, this last, my lord, the documents saying that the petitions are pending, my lord. Just
which petition? High Court litigation.
Yes.
That you have already said.
Yes, ma'am. That's there. Now, my lord, may kindly see this all the tenders, both of the tenders were floated simultaneously on the same date, ma'am.
Where one you have already been allotted.
Yes.
And this you have been rejected.
Yes. I have submitted, madam, submitted documents which I had, madam, because that it is a very tedious, madam. It has to be scanned and uploaded to website, madam. So definitely I will upload the documents which I have, madam. I cannot manipulate it. Now, this tender where I was successful, madam, due to some litigation, pending litigation and all that, madam, it was not open, madam. Those controversies were there, fights were there, all those things. So its technical bid was not open. Well, when this present technical bid was open, it was open later on in October. Then I'm qualified in that one, same set of documents. How there can be two criteria? In 2 tenders, I was disqualified. Your Lordship just disposed that, in there I was qualified for the same ground. ditto ground, my lord. And this also I was disqualified on this ground.
That also you are disqualified, that one.
No, in
The one which is just
yeah, same ground, my lord.
disqualified.
You disqualified. Same ground that you have this documents.
That disposal is not going to affect
No,
your
no,
merits
I'm
here.
saying my lord, same ground. In two bids, I was disqualified on technical, my lord, in the technical bid. In the last, which was open later on after 3-4 months, my lord, in that I qualify, my lord. They don't find any defect with the documents, man. How there can be 2 yardsticks for the same set of documents? If I'm disqualified in all the tenders, my lord.
Yes.
If my documents was not genuine, my lord, then I wouldn't be qualifying in any of the tenders, man. That means the authority knows the action that they have taken was to favor, because all those defects I've shown in the petition of the respondent 5 and 6, they have overlooked that. Total favoritism is totally arbitrary, the action of the respondent authority. What I'm praying in this petition is, let my technical be qualified, because you have already qualified in the another that one. In the price bid, definitely the authorities have the choice to award the work to any of the successful bidders.
But what is your price bid?
That,
Is it more than less than the petition?
yes, my lordship last time asked me, and I have found my price bid is, your lordship directed me to give a copy of that one. Lordship.
What is the price?
My lord, make the price bid.
No. That has been accepted?
That, my lord, page, your lordship, just. Yeah.
What is your price bid? 2 crore?
Yes.
23 crore?
Yeah, 23 crore.
23 crore, 79 lakhs.
Yes.
56,000. 550. And prior respondents?
Marat is 25 crores. This 25 crores, 34 lakhs, 76,583. 34 lakhs, 76,583, man.
Around 1 crore 40 lakhs.
Yes, madam.
Yes.
Mala, this is my humble submission. Mala, it's a total arbitrary reaction of the respondent authorities. Therefore, Mala, the impugn technical and financial, we have prayed for setting, quashing and setting aside those 2 orders, and directing the respondent, petitioner to be qualified for the financial bid. That's all, Malad. I'm cutting short, Malad.
Any decision you'd like to show?
Malad, I'm just, I submitted one, madam. 1994, 6 SCC.
Name.
Madam, this is Tata Cellular versus Union of India.
1990.
You'll have to be aware of this one. 6 SCC, 651.
651. Tata Cellular.
Yes.
Paragraph.
Madam, the paragraph mainly 77, man.
Judicial review.
Yes, ma'am. Duty of the court, ma'am, whether decision-making authority exceeds power, ma'am. Committed error of law, committed breach of rules, natural justice, reached decision which no reasonable tribunal could have reached, ma'am. It starts paragraph 77, page 677.
Yes.
Of course, madam, the judicial review, the Honorable Supreme Court has said my judicial reviews are limited, madam, in matters of tender, madam. But in such a cases where there's a gross illegality, arbitrariness, this court has the power to, madam, interfere. That's there. That's all. Madam, and one thing, madam, I wanted to answer that one regarding the same documents being uploaded in different bits, madam. It is not the case, madam, that one would be, madam, successful in every bid, madam. Definitely, some other bidders might be lower in price, technical, and much be more sound, madam. In this case, madam, in Arunachal, only 3 works are allowed, madam, at a single one point of time. The bidder, the tenderer cannot bid, madam, to have more than 3 works. That restriction has been put.
Yes.
Machinery is a manpower can be always be shifted, according to need. That's all that.
Yes.
May I please? My lord, in case of PMJS, there is no restriction. Bidders can participate they can about 3-4 work also. There is no restriction. In case of PMJS, it's a global tender. Now, my lord, I'll first come to the packages where the petitioner participated. Altogether, he participated in 4 packages. That is package number 0303-268 road from Krimapao Road to Raro, the present case. Then package number 03.
He participated in 4 packages.
4 packages.
Okay. Yes.
And 3 packages, including this where this cases he has filed. In earlier also he case filed withdraw IT. 3 packages was evaluated on 2nd August 2024. 2nd August
2024.
2024. Yes.
You the technical evaluation.
Technical evaluation. That was evaluated on by the same committee.
For 3 packages.
For 3 packages, including other packages also. There were several packages. Then, in all these 3 packages, till then, other packages where he was successful, it was not open till then. In all these packages, he have furnished same set of machinery, then same set of technical persons.
Yes.
So his bid was in one of the packages, it was from different division. It's a Chiang Tajo division. Remaining 2 was from Bameng division. So if the work is aborted, even if the 2 work is aborted, there is no limit that he should not be awarded 3 or 4. Even if 2 work is awarded, then it will difficult for him to deploy the one set of person or one set of machinery in a 2 different project. All these projects are very important.
Where are these reasons recorded?
My lord.
Where are these reasons recorded in your minutes?
My notes is not required. The provisions they have given the,
Provisions we have seen.
yes, that is the,
Provisions, first one, 4.4 B1
yes.
is with regard to the
Availability of construction.
name of the equipments, machineries.
Availability.
4.4 B2 is personnel. 4.7 is misleading, misrepresentation, or record of poor performance.
Yes, 4.4 B1, availability of construction. So ability for construction either own or lease.
So where have you recorded that there will be shortage?
They have given the clause only.
No, that will not be enough.
My lord, let me go. Then the
It will be a very good reason, but
yes,
that reason has to be assigned. Where is the assignment of those reasons?
they have given the clause. From that they can find out. Then the package which he was success was evaluated on 20th October 2024. That is after a gap of more than more than 2 months. And here even one of the member was also changed. One of the technical evaluation committee members. Here in this, where he have successful, the executive engineer of that division, Cheng Tajo division was the members. And where he has rejected, he was not the members. There is other members. So their opinion might have changed. Then regarding
Mr. Tarak, we are not on the individual who were present or who were not present. We are on the reasons which have been cited for cancellation.
yes, my lord. Then we have made an allegation that invoice which he have submitted
Yes.
regarding the machinery, it is paid. That has been not replied. He has not filed any reply. And we have allegation that read petition number WPC number 244 AP 2024. It is still pending to, but he has not replied to that part also. And he has tried to compare with other also they have read petition. That part also he has not replied. Then regarding
But invoice, if the invoice are fake, same invoice you are accepting for another bid.
my lord, that what I am submitting is that
These are not subjective satisfaction, these are objective satisfaction.
that they may change their opinions at a relevant point.
No, opinion cannot change objectively. Subjective opinions can change. But it's a document. If it's a fake document, whoever examines it, it's a fake document. My handwriting is very bad. You may say, no, it's a good handwriting. Okay, subjective. But if a spelling is wrong, that is objective.
Otherwise also, my lord, now the technical financial bids, the bids amount which you have submitted, that cannot be relied upon, whether it's authentic or not, we cannot understand. Unless we open the financial bids from the portals, that we cannot substantiate it.
No, we are not even going to that issue.
With that.
We are only asking that whether if we are inclined in favor of the petitioner, will it be a futile exercise if his financial bid is lesser than the private respondent? He says that my financial bid, if his financial bid was higher, if he says that my financial bid is lower. So that is why we are still going ahead with the process of adjudication. Otherwise, there is no process, no.
My lord, otherwise also there is a ground for rejection of his technical bids. At this stage, now financial bid already open, work has been awarded. Now the successful bidders, he has already executed more than 60% work has been completed as informed by the department.
60%?
50%.
50?
more than 50% work is completed. At this stage, since the petitioner have also other remedies, alternative remedies, if he can success by filing a civil suit.
Now,
No.
at the time of hearing.
Later. There is other alternative remedies for him by filing civil suit. He can file a civil suit if he really feel agree by the decision of the authority, tendering authority. So my humble submission would be at this stage, since this
Why
project
are
is,
you remitting him to a civil suit?
my lord, this is the decision of the
And
apex
why?
court of observation.
If the rate is not maintained,
Otherwise,
why should he go to a civil court?
we have alleged that his invoice is also paid. He has not replied that there is ground of rejection. Otherwise, the record we have brought, I have brought, my lords, the documents which he furnished is same document he has furnished.
Now, where are the reasons? You just show us the reasons of rejection.
Reasons in every,
Apart from the quotation of those clauses at page 122.
my lord,
At
as
122.
in today, in inter-tender rejection, only they used to cite the clause. That in future I have to inform them to give the reasons. Till now, their practice is like that.
No, suppose in a given case, you had only cited 4.71.
Yes.
What is 4.71? 4.71 is representation or misleading.
Misinformation, yes.
Now, if you cite without even showing what has been misrepresented
Yes.
or misled,
Yes.
then that will not suffice.
Now that is true, but
No, just for your, since you had said that till now, you have only been citing the clauses and not the reasons. Suppose there is a matter, a situation where there has been gross misrepresentation, misleading. You have only cited the clause. You have not even stated what has been misrepresented, what has been misled. It will not be a transparent process. He has to be informed that this is the document by which you are misrepresenting.
yes, that part, that is there.
Now, the fake documents, where have you stated it's fake documents?
Now we have in the evaluation they have not stated. They just give the clause 4.71. That's misrepresentation. It covers entire things there. They have clause section itself covers.
We have to go to 1952. Police Commissioner's case.
My lord.
Yes, Mr. Tafo, you have not even shown Police Commissioner's case 1952, page 16. Yes, well, bring it. Here, 1952. Paragraph 8. Yes, what do you want to show?
I want to I am citing from NG projects. This is.
See, NG was on a different, that is after the amendment of the Specific Relief Act, age.
Yes. NG project, and I'll cite.
That has been, subsequently, it has been diluted. It cannot be that.
No, it has been taken from cited from Jagdish Mandal.
Jagdish Mandal, okay, Jagdish Mandal. NG projects, there are different views after NG projects. This is mainly on the, after amendment of the Specific Relief Act.
I'll read one paragraph only, my lord. That is para 16 sub para 22.
Please give the citation.
Page 414.
Citation.
2022 6.
2022 6 SSC 127.
2022
6 SSC 1 page 127.
NG projects.
Yes, NG projects.
Paragraph?
Paragraph 16, then subparagraph 22 I'll read. Paragraph 16.
16 and?
16 I'll skip. Subparagraph 22.
Of?
Page 1.
22 of 16 or what? Subpara or what?
There is another para is giving.
Is it quoted from another
Quoted,
judgment?
Which judgment?
Jagdish Mandal.
Okay, you are having Jagdish Mandal, okay.
Yes.
Okay.
Judicial review of administrative action intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matter relating to tender or award of contract, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contract are essentially commercial function. Principle of equity, natural justice stay at distance. If the decision relating to award of contract is bona fide and is in public interest, court will not, in exercise of power of judicial review, interfere even if procedural aberration or error in assessment or prejudice to tenderers is made out. The power of judicial review will not be permitted to be invoked to protect the private interest at the cost of public interest or to decide contractual dispute. This construction vibrant village is border areas. This is public interest projects. So at the cost of the unsuccessful bidders, it cannot be intervened at this stage, since the work is in full swing. If this court interferes, then it will again hurdle the development activities. Since there were so many litigations since from the very beginning in these projects. Even the petitioner have filed so many cases and they withdraw again, file again, withdraw again, file. This is the last stage of litigation.
Why are they withdrawing?
On different grounds, some for
He has
technical.
filed this petition before also.
Yes, madam.
This cause of action.
Yes.
Why did you withdraw?
Madam, there was technical defects, madam, so we have withdrawn and with the liberty to file afresh.
In one stage, he withdraw because of some. We have raised some objection also. So there are so many decisions, my lord. So at this stage, my lord, my humble submission would be, since the execution of work is going on smoothly, so if it is interfered, then again there will be a lot of difficulties. Opening of the financial bid at this stage itself is not even possible.
Why?
By this time, I think even e-portal, whether it exists or not, I'm not sure, but there is no instruction. It remains for certain periods. And even this, the ground which is sought of the same set, there is different time period, my lord. Different time period. One of the member is also different. There can be a different of the opinions. That can be possible. Maybe their human empathy may be there. Then be able to, at this stage, since the apex court have clearly stated, if you have any grievances, you can always go for other remedies by filing civil suit, damages.
You have just said that you cannot open the financial bid even in the civil proceedings.
My lord.
And you are sending him to a civil suit, which should be decided after 5 years.
That if he succeeds, then he will get something. So my humble submission, this case is fit for dismiss.
Yes, Mr.
May I please, Your Lordship? My lord, I do not know if from the records, if they are showing that only the clauses mentioned in the evaluation, that these are the clauses based on which your tender has been, technical bid has been rejected. But then, my lord, when the documents are very clear and which match with the clause, and here the ground is so far as
You have a
equipment
response number?
5, my lord.
Yes.
Lordship has seen at page 122, the grounds of rejection are basically 3.
Correct.
And number 1, which your Lordship has already seen at page 42.
Yes.
He has admitted, the petitioner has admittedly submitted 3 bids for 3 different packages. Now, if he does not show either in the writ petition or in his bid documents Let's see, if I am awarded work in respect of all the three packages, then I'll forego remaining two. That he is not saying. That he has never said. Till today he has not said.
That he'll forego?
And if he is allotted work in this work order in respect of all the three packages, then because of non-availability of adequate staff and adequate equipment, he will forego the remaining two work that he has not said anywhere.
No, he is not foregoing.
How should that is what I am saying, my lord. Now, with the same set of documents and staff and engineers, how can he perform work in three different packages? If he's allotted
That
in
is
three
your
different packages,
speculation. How he
how
performs it? No, that is only your speculation.
No,
for
my lord,
private-
that is
No, where is
my
it?
lord,
Where is it?
my lord,
Where is it coming from the department?
my lord, my submission will be, it is the speculation of the petitioner that he will get only in one. So far as the authority is concerned, my lord, authority is to presume
No,
that if he is granted.
how can you anticipate about the speculation? He has participated in three bids. He wants all the three works
My
to
lord,
be
that is-
allotted to him.
My lord, my submission is, how can the authority or the petitioner today say that he will not be given work in respect of all the three?
This question, how can you raise?
My lord, I am saying,
As a competing bidder, it is for the
My
department to say.
Lordship is
Department has
absolute.
not said. And
Lordship
department
is-
cannot say now in the proceedings. Department has to say in the proceedings by which his tender has been
Evaluation.
rejected. That is the law.
Evaluated.
It may not be a very
My lord,
elaborate
your lordship is correct.
reasoning.
Your lordship is
It may not be a very elaborate reasoning, but it has to be
Yes.
in such a manner that it appeals to a
My lord.
reasonable person.
My lord. My lord, your lordship is referring to Gordon Das of AR 52 Supreme Court, page 16,
Yes.
possible.
Gordon Das
My lord,
has been followed
I'm
thereafter
conscious.
in Mahinder
My lord, I'm
Singh
conscious.
and all the cases.
Yes, my lord, I am conscious of that. My first submission, your lordship will kindly record, is that if he is entitled to participate in all the three packages, and any PMGSY scheme doesn't prohibit participation and issuance of work order in respect of all the three packages, then it is for the petitioner to show and say clearly that, see, if I am allotted work in all the three packages, then I will forego two. Otherwise, the authority has to go by his bid documents, and authority has to decide on the basis of the documents he has submitted. His documents are same documents, same person for all the three packages, which is not permissible in my humble submission under the tender documents. This is my first submission, my lord. And subsequently, in a different package, when he submitted the same documents for one package, it was accepted, and rightly so. Because for one package, these are valid. Same set of documents for three packages will not be valid. For the simple reason that in three different places, he cannot keep on moving things. Otherwise, he will work very slowly. After 6 months, he will do one work, and the authority cannot raise any objection. Authority then will be stopped from raising objection on the ground that the three different sets of documents are not available with them, or personnel are not available with them. That ground will not be available to the government once they issue work order in respect of three. So that is why they have rejected, rightly so, my lord. And the second one is, my lord, with regard to pending litigation. It is an admitted position that the petitioner was a petitioner in two other litigations, and he has suppressed that. And that is why there is an allegation that due to suppression, his tender has been rejected. Third ground is suppression. And the petitioner has admitted that, my lord. Yes, there was a suppression.
Regarding the litigation faced by you?
Madam, I am a respondent. When anybody files a case against me, how can I be responsible?
No, it's not.
I'm a respondent.
It's not a question of being responsible or being responsible for to initiate the litigation. If there is a litigation where you are involved, wasn't it your duty? Yes, I am a respondent in this. There is a litigation against me where I am the respondent.
Your lordship is correct that I am a respondent, but if I am respondent, my lord, I have not initiated the policy behind this is that if you are filing cases against the department at the same time you are participating in a bid.
No. That will amount. That will be a different. This proposition will not be accepted. As if you are trying to curtail the right to a party to approach the court of law. That cannot be. If
Yes.
one has a legitimate cause, why shouldn't he be? Why should he be precluded from
Madam,
coming to the court?
on that ground, madam, I'll be relying on one judgment to support my submission that if there is a defect in respect of one particular aspect of the tender condition, and if both the parties have, then the petitioner will be not having the locus to challenge that. My lord, I'll be relying on one judgment on this issue, my lord. So my lord, first submission is, my lord, it is absolute, the authority has absolutely taken a right decision in rejecting his technical bid on the ground that for same set of documents he has relied on for the purpose of performing his work in 3 different places. And the second one was, my lord, Lordship will find at page 42. First one is equipment, second one is technical personnel, my lord. And third one is suppression with regard to, my lord, pendency of litigation. So first two is, my lord, absolutely clear from the record itself that he did not have 3 separate sets of technical person and equipment for performing the job, my lord, work. So that is my submission, my lord, and in that way the matter, and after the we say, my lord, 90% work we have completed so far as art cutting is concerned. My lord, so far as art cutting is concerned.
Department says 50%.
No, 50% of the entire work, my lord.
More than 50 means what? 100.
My lord, I'm
More
saying
than 50 cannot be 90.
no, my lord, I'm saying about art cutting.
No, art cutting is one of the component only.
Yes, my lord. So
Total
far as
work.
art, my lord, of the 13 kilometer, I have completed almost 11 kilometers, my lord. 2 kilometers have
What
left.
is the total progress of the work?
13 kilometers.
No, what is
13
the total?
kilometers.
No, in terms of percentage, what is the total percentage of completion of progress of the work?
It will be, my lord, above 60% of the total work, my lord.
The department is already disputing. Tomorrow there will be a limit. There may be a
That I have to take
between you
calculation
and the
engineers.
department.
My lord, I'll be relying on 2 judgments. I'll cut it short, my lord.
Please.
My lord, from Tata Cellular, my learned friend has relied on para 77. I am also relying on para 77.
Okay.
My lord, para 77, if your lordship goes to the second part, my lord.
Yes.
It says, my lord, therefore it is not for the court to determine whether a particular policy or particular decision taken in the fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which the legislative action is subject to control by judicial review can be classified as under, your lordship is aware, illegality, irrationality, and procedural impropriety.
Yes.
Then the last sentence is, in all these cases, the test to be adopted is that the court should consider whether something has gone wrong of a nature and degree which requires its intervention. And here what is happening is, my lord, that there is some, so far as, my lord, first ground is concerned, authority, in my humble submission, subject to your lordship consideration, my lord, is absolutely right in rejecting, because one cannot be expected to perform in 3 different places, in 3 different packages, with same set of document and same set of equipment, my lord. So far as third ground is concerned about pendency of litigation, if your lordship ultimately comes to a conclusion that this defect was there in respect of both the petitioner as well as respect of 5, then, my lord, I'll be relying on one judgment of 1999, 1 SSC page 492, that is Roanoke International, my lord.
99?
99, 1 SSC page 492, my lord.
Roanoke International.
My lord, your lordship is aware of that, my lord.
Yes.
Yes, ma'am. My lord, in Roanoke, what has happened, my lord? The Roanoke International was allotted to work. The writ petitioner was not allotted to work, and an interim order was granted. Then the matter came up to Supreme Court, and the Honorable Supreme Court, my lord, lordship will kindly see paragraph 8.
Yes.
At page 499. This is not a case where any malafides have been alleged against any member of the board, nor is there any allegation of any collateral motive for awarding the contract to Messrs. Roanoke International Limited. The only ground of challenge in the writ petition filed by Mr. So-and-so is that Messrs. Roanoke International did not fulfill the qualifying criterion of having laid such pipeline for a distance of 3 kilometers. But the challenger, so-and-so, also doesn't fulfill the qualifying criterion. In these circumstances, we fail to see any basis for passing the impugn order. There was an interim order, my lord, passed. So, similar is the observation in para 11 again. when a writ petition is filed by the High Court challenging the award of a contract by a public authority or the state, the court must be satisfied that there is some element of public interest involved in entertaining such a petition. If, for example, the dispute is purely between two tenderers, the court must be very careful to see if there is any element of public interest involved in the litigation. A mere difference in the prices offered by the two tenderers may or may not be decisive in deciding whether any public interest is involved in intervening in such commercial transaction. It is important to bear in mind that court intervention, the proposed project may be considerably delayed, thus escalating the cost far more.
Mr. Mazumdar, just a minute. Mr. Tafu,
Madam.
did you, have you alleged in the writ petition regarding pending litigation so far as the respond number 5 is concerned?
Yes, yes.
In the writ petition?
Yes.
That litigation was pending?
Yes.
That he has raised. Madam,
Even
that he has raised.
NXT order also.
In the writ petition or as a
Yeah.
reply?
In the writ petition.
Okay.
So these being the position, my lord, in the last sentence of paragraph 11, it is said, therefore, unless the court is satisfied that there is a substantial amount of public interest or the transactions entered into mala fide, the court should not intervene under Article 226 in the disputes between two rival tenderers. Here, my lord, dispute is between two rival tenderers. They are disputing my one, and I am saying they are also not qualified. So this being the position, my lord, when he himself is not qualified, he doesn't have any locus. And it's a case of, it's a tender is for a vibrant village. In the bordering areas of the country, my lord, there is a need to, my lord, construct the roads for better communication. And that is why this has been, this scheme of vibrant village program has been undertaken. And under this NIT has been floated. So that being the position, my lord, the petitioner, there is no public interest is involved in this case. Petitioner has raised certain dispute of which he himself is suffering. And so far as first ground is concerned, my lord, I am with all my lord, humility submitting that my lord, that there is a defect because same set of document and same set of people cannot perform in three different works. And authority cannot be expected to presume that he will not get work in the remaining two. That being the position, my lord, my humble submission, the petition is liable to be rejected. And no public interest is at all involved in this case.
Mr. Mazumdar, if
My
we
lord.
come to 4.7,
My
as far
lord.
as the last argument which you had, last point which you had taken up in your argument
My lord.
regarding the pending litigation and
My lord.
the paragraph 11 of Ronak which you have relied.
My lord.
Let us test your argument with the provision of 4.7.
4.7.
At page
Yes.
44.
My lord.
What are the expressions used in this provision and how does it apply to a pending litigation?
Page 44, my lord.
Page 44,
Yes.
4.7.
Yes. Page 44, 4.7 says making misleading or false
But
representation.
first, now let us read it. Even though the bidders
Meet the above qualifying
they
criteria.
are subject to be disqualified. So this is a
disqualified
very
if
discretionary power
My
which is
lord.
subjective in nature.
My
What is the
lord.
first one? Made
Misleading.
or false representation.
Yes, my lord.
They have to file affidavit that there is no litigation pending. They have to-
Misleading or false representation. In the forms, affidavit, statements, affidavits and statements, attachment submitted in proof of the so and so. Record
My
of
lord.
poor performance such as abandoning the works, not.
Remaining two are not necessary, my lord. Those two are remaining 2 and 3 are not relevant in our case.
Where is the requirement of affidavit?
The petitioner, he himself has filed affidavit.
Where is the requirement? Where is the format of the affidavit?
Affidavit, I think it must be here.
There is one affidavit formatted 106. I don't think this is the.
There is, they have to.
Yes, page 106, there is one affidavit.
That is, I think that is not the one which you are looking for.
Page 104, I think, ma'am.
104.
Form of B, that is form of B,
No,
madam.
no, not this. This we have checked. This is not the one.
Might, ma'am.
And one more point you have not covered, Mr. Mazumdar, is the allegation that the bank statement, bank certificate.
Bank certificate, I have correctly given my lord, and the my lord, the government affidavit, lordship will kindly see, they have mentioned that I have given the correct thing.
Okay.
Lordship will kindly see the government affidavit, madam. Page, para 10-1, my lord.
In his
Para
documents here,
10-1.
undertaking on litigation.
10-1.
10-1.
10.1.
My lord, that no
Where
bank
is the-
certificate.
where is the
From record, it revealed that he have filed that there is no litigation, even litigation he have made nil. There is.
no, which is that form?
The form. I think there is some one clause which he has to punish. As per that clause.
Show that clause.
Non-litigation, I think is there.
Okay, we come back to, kindly show that part. We have almost completed. We'll go have a rejoinder of Mr. Tafu if
Yes.
you are inclined. Short rejoinder, then I'll close this.
My lord.
My lord, I just wanted to reply on, my lord, regarding Wasim documents have been submitted in all the tenders, my lord. Well, if the authority wanted that only one tender, one person should participate in one tender, my lord, the tender itself would have clarified that you cannot participate in more than one tender, my lord. But that limit has not been put.
Yes.
In otherwise, in PMGs wise clear, you cannot participate more than three
That
tenders.
has been clearly.
Yes. So, my lord, the respondent authority is not saying that you cannot participate in more than three tenders with the same set of documents. That is not the stand of the respondent authorities. As far as, my lord, the work progress is concerned, if we, my lord, exaggerate it also, if we believe the government has said 60%, my lord. If we admit 60%, my lord, component, that's a formation cutting only. Formation cutting, my lord, would be a maximum 30% of the overall work. My lord. If we estimate that, my lord, then also hardly out of this 25 crores, only 350 or 4 crores of work has been done. My lord. If we conservative that estimate, if we accept the government's stand also, the substantial almost 90% of work is still remaining. And now, possibly in the state of Arunachal Pradesh, like rainy season, after this, no formation cutting would be there in any of the places. Because the rain is such, no formation cutting can be done. Only in September, October, it will once again start.
What about the closure of the e-portal?
Malad?
What about the submission that the e-portal has been closed?
No, the e-portal, Malad, is the client, or it depends on the Malad client. The government is the client, Malad. the portal which is handled by the third party, my lord. They cannot of themselves close it day one. It can be open anytime, my lord. It's the client which is, and that portal, my lord, it will remain forever on the site, web, my lord.
No, does your contention or Mr. Mazumdar's contention will not be so significant in the matter of this nature, closing of e-portal.
Yes.
Will have the
Mal-
views of Mr. Tarak, because they are
Mal-
the department.
Yes.
You or Mr. Mazumdar may not be too much even concerned
Yes,
till one
ma'am.
period, or may not have the technical know-how. Yes,
Mal-
e-portal is,
Well, this case, I have no answer, but in other case, the other instruction which in other case, they used to instructed me that once it is closed, it is difficult.
now once it is closed, it is difficult, but is it closed in this case?
It will close. Once the technical open.
It will, and it has been closed, will have two meanings. Has it been closed? Do you have instructions or?
That part I have no, so that part I have to take instruction.
Okay, anything else? No. Okay, then we'll close this.
Vale.
We'll consider.
Much obliged.
Heard. So repeat of 4 learned counsel for the petitioner. Also heard Sri G. Tarak, Learned Standing Counsel RWD. Full stop. Sri D. Mazumdar Learned Senior Counsel has appeared online for the response number 5, who is assisted by Sri. Please write his name. Huh?
I'm appealing for response number 6.
Full stop. Sri P. Bora.
Yes.
Learned Counsel, who is 6?
6 is the one who is who was awarded selected on the technical bit along with the respondent 5. But
You had also qualified in the technical
Yes,
bit.
yes.
P. Bora for
In the
response
financial
number
bit-
6. Correct. The arguments have been concluded. Judgment is reserved.
Your lordship was searching for that, inquiring about that affidavit, requirement of filing affidavit.
Yes. Yes,
That-
yes, yes.
There is,
Where is the format?
That
there
that
is
is
no
at
probate as such, but
My
as per.
page 38, lordship will kindly see,
38.
my lord, of the read petition.
Yes.
NIT clause 5, page 38. It says original affidavit regarding correctness of the information furnished with bid document as per provisions of clause 4.4BA2 of ITB. And that your lordship will find at page 42. Page 42 at the bottom, my lord.
Page 42.
4.4BA Roman 2, my lord. I just wanted to point out this, man.
Roman 2.
No, that we have seen already.
My lord.
Appendix.
The page more clear is.
We are on the format of the affidavit.
Format,
What is
yes.
it required to be disclosed?
My lord.
No, my lord is written given here.
And it's mentioned
Uh,
correctness of the information furnished with the bid document.
No, no, the requirement of pending litigation.
Page
Where is it?
41 of writ petition.
41.
Clause I. Information regarding any litigation or arbitration during last 5 years in which the bidder is involved, the party concerned, the disputed amount and the matter. This has to be furnished. And here petitioner furnished, but it said nil. (4.2)(I).
Yes, 4.2I.
Okay. That have submitted. Respondent 5 also did not submit, madam. There's not substantial defect. That's my argument. Okay.
There was no stay from the very beginning, my lord, so we have continued with the work, my lord. That will consider it.
You should have completed the work. Okay.
Obliged.
May your lordship?
Yes.
May your lordship? Lordship, as per the last order dated 2/4/2025, the respondents were supposed to bring instructions.
Which
And
respondent? Health department?
yes, your lordship.
Yes, what is your, have you filed affidavit?
No, till date.
Why? 25
And-
matter, okay, we grant you some time, can you file the affidavit? No pleasure.
Lordship, here. May I, your lordship? Lordship, the petitioners here in other Ayush doctors, your lordship. And then in the year, what had happened is in the year 2007,
Let
the
them file the affidavit 25 matter. Okay.
Yes, your
But
lordship.
we file it.
Last
in this
occasion also they were supposed to file, but short date may be given, your lordship.
time. Okay. Heard Miss N. Anju, learned counsel for the petitioners. What's the claim? Sarah? Oh, on the prayer of three.
On behalf of Tita.
Three students appearing on instruction of Sri Tita Gum, Standing Council Health Department. 3 weeks time is granted. Further 3 weeks time is granted to file affidavit in opposition. Full
No.
stop. Please this case, we fix a date.
Yes,
Place
your
this
lordship.
case on, but file it within this 3 weeks. Today is 20. Today is 19th, okay. 1, 2, 3. We'll have it on 10th of June.
Lordship. Obliged.
Please file.
10th
10th of June.
Item number 14.
Yes.
May I apply to you, Lordship? In this, the respondents, they have not filed yet affidavits here. This is related to the acquisition of land.
Notice was issued when? 7/5.
Notice was issued.
State is by whom?
Yes.
Madam Basar and Mr. Khera for Power Grid.
My lord.
Affidavit not filed.
Yes.
Should I have not received extra copies yet?
Why don't you give, Khera, you have got extra copies.
My lord, we don't need extra copies.
Okay.
My lord, we have received instruction.
Okay, you
Take some
file your
time to file an
affidavit? Okay. Sri S. Mahu, learned counsel for the petitioners, undertakes to serve extra copies of the writ petition to Ms. Basar, the Learned State Council. Full stop. Both Ms. Basar, the Learned State Council, and Sri N. Khera, Learned Counsel appearing
Respondent number 4, my lord.
for the Power Grid Corporation of India have prayed for and are granted 3 weeks time to file affidavit in opposition.
My lord, we had also on the last occasion, my lord, we had raised the issue of indemnity that may also be kept open.
And that is open.
And I'm also praying for the interim, your lordship, because this is,
No, the interim order shall be considered only after deciding the issue of maintaining
My
leave.
lord.
So we'll issue, have the issue decided, then we'll consider.
obliged.
Pleasure.
Readings are over, Lordship. Matter may be fixed for admission hearings.
21 matter, why admission hearing? We'll have it for hearing. Yes, admission hearing finally will dispose of. What is the issue about?
Here, Lordship, petition.
Babura.
Yes, Lordship.
Okay. Why is it listed for orders? All the respondents served.
Yes, Lordship.
They have been represented.
Yes, Lordship.
Respondent number 2 has not filed affidavit. Filed or not? In the meantime, Madam 2, you are for 2. Who is 2? Madam Pangu? Who is the secretary? District administration. Is it required? Who has filed? Any of the respondents has filed affidavit?
Deputy Commissioner has already filed.
That will suffice.
That will suffice.
Okay.
ठीक है, फाइल करता ना.
The pleadings are complete. It has also been clarified by Sri Astapin Learned Senior Advocate that the affidavit filed by the Deputy Commissioner shall cover the stand of the official respondents. Para? Since the petition is of the year 2021, list for admission hearing when? On we'll have it on 27th. Okay, next Tuesday, 27th.
Interim order, let me be continued.
Interim order is there. Interim order passed earlier to continue till the next date of listing. What is this IA for?
Vacation of interim order, Lordship.
Huh?
I for vacation of interim order.
Okay. You have not pressed this, so it was filed in 2021 itself. Okay. The final writ petition will be heard, no problem.
Highly applaud.
Your Lordship, in this matter, we are supposed to take this step on the respondent number 2, which we have already taken on 27/10/2024.
When did you take?
27/10/2024. And as per 27/10/2024.
No, but after that matter had come on 25.
Yes, Your Honor, but matter couldn't be taken on
Where are you? Do you have any documents?
We have taken a report here.
Who is R2?
Pardon?
Who is this one number 2?
It's a private company, Changam
Private
Enterprise.
respondent.
Yes, yes, Your Honor.
Now, where is the document? This is the postal record. Where is the document that you had given to the court? Was it sent through the court?
Yes, Your Honor.
And how did you get this?
We have taken the consignment from the court here on the from this record room.
Okay. With regard to the requirement. Okay. Oh, no. First steps. When was first step directed to be taken? Now, fresh steps were directed to be taken by which order, madam? Fresh steps, okay, 2, 3. 2, 3. Twenty-six, 7. 26, 7. 29, 29. On the issue of service of notice upon the respondent number 2 by taking fresh steps, Miss so-and-so, please give your name. When it comes for the petitioner has submitted that fresh steps were taken when? On 4/11/2024. And she has also presented the concerned postal receipt and postal track report. Postal. The aforesaid documents are to be submitted to the registry for ascertaining the matter. Whereafter, a fresh service report is to be given. Full stop. The matter may be listed accordingly after 10 days. You submit this in the registry, okay? Madam,
Yes, Your Lordship, I'm appearing for 1, 3, and 4.
affidavit filed.
Not yet, Your Lordship.
Why 22 matter?
Yes.
Secure for
And for 5 lakh.
affidavit filed.
Okay.
Okay.
Lordship, may kindly allow us.
Seeking compensation against the.
Okay. Miss Sangeeta, the learned State Council, raised for and is granted 3 weeks time, 3 weeks further time to file affidavit in opposition. Also heard Sri R. Sekia, learned counsel for respondent number 5, who however submits that affidavit from his client may not be necessary. Oh, first you write 10 days, na? Don't put 10 days, na? List accordingly after 3 weeks.
Obliged.
That remove the 10 days.
Video.
18 years.
Yes, may I please, Your Lordship. Well, this is contempt was filed. Well, I ordered that Your Lordship may see the order start from page 15. Page 15 and
Notice was issued.
the issue was that
Notice has been issued.
Lordship, yeah,
You have filed affidavit.
here, direction is to consider the representation also. Direction was to consider the representation.
Representation.
Representation, and it has been already considered and disposed.
Oh.
but the representation, Your Lordship, detail the grievances was in the representation, but then as per the this is order which is in enclosed in page 23. Page 23. Just read, my Lordship. I'll just read the second paragraph. Conduct comprehensive physical re-verification. That's what the main issue. At the ground level of package 5, Lada Sarli Frontier Highway. It may be noted that the re-verification exercise was undertaken as per the order that is such and such 06/01/2025, wherein official comprising of land, forest, agriculture, and horticulture department physically verified entire stretch of frontier highway within East Kamen district. But Your Lordship, it has to, they should have filed a detail how they have verified the who were the officers and whether they have visited the places of the petitioners. That detail is not there, Your Lordship.
Will it be a contempt? Contempt has to be a deliberate and willful disobedience.
Yes.
Accordingly, the petition is disposed of by direct deputation to consider represent subpoena and subsequent reminders to pass a resent and speaking order.
But this is not a, Your Lordship, my submission is that this is not a speaking order.
You can challenge this separately, not by a contempt. Sorry.
Okay.
Heard Sri Asma, learned counsel for the petitioners who by means of this petition had alleged willful and deliberate disobedience of the order dated 10/3/2025 passed in WBC 98 of 2025. Full stop. Para. This court by the order dated 10/4/2025 had issued notice pursuant to which Sri S. Tapin, learned counsel, has entered appearance on behalf of the sole respondent.
Sole respondent.
Sole
That's why we
respondent.
move on.
Sole respondent. Sri Tapin, the learned counsel, has contended that there is no disobedience or violation of the order of the court, and rather the said order has been complied with, leading to passing of the order dated order dated 2nd April 2025. Full stop. Para. On the other hand, Sri Mao, the learned counsel for the petitioners, has submitted that though order dated 2/4/2025 has been passed, the same is not a detailed one and does not contain reasons, which was the direction of this court. Para. To appreciate the rival submissions, the operative portion of the order of this court dated 10/3/2025 is perused, which is extracted herein below. Page 20, para 8 and 9. Para. It, however, appears that while the order dated 2/4/2025, the respondent has passed an order which itself reflects that it has been passed as per the direction of this court dated 10 direction of this court to dispose of the representation. Full stop. Para. Though Sri Mao may have some force in his contention that the aforesaid order is not a reasoned and speaking order, this court has noticed that in the said order, the background facts have been taken into consideration. Full stop. Though the order may not be a very elaborate one, comma, it cannot be construed that there has been an willful and deliberate disobedience of the direction of this court. Full stop. A proceeding under the Contempt of Courts Act has to be against an action which is deliberate and willful and not for anything else. Full stop. While the petitioners would have or may challenge the aforesaid order in the manner prescribed, the same cannot be construed to be in violation of the direction of this court. Full stop. In view of the above observations and discussions, the instant contempt petition is closed. Full stop. Liberty, however, is given to the petitioners to challenge the order dated 2/4/2025 in accordance with law.
Obliged.
May I please, my lord? This is a transfer matter, my lord. On various orders of this honorable court, my lord, either to file affidavit or to produce the records, my lord. The petitioner, my lord, and
Affidavit filed?
No, not filed, my lord. And probably, my lord, they will produce the record, my lord.
Records produced?
My lord, the petitioner is, my lord.
Private respondent, madam, you are for private respondent? Anyone for private respondent?
They have not.
You have filed Dusty, I think?
Yes, madam.
You have filed affidavit for the Dusty service?
Yes, madam.
Nobody is appearing?
No, madam.
Orders passed for There is a direction for consideration of the interim order. also.
Yes, madam.
Even that can be done if,
Madam.
or you can take up the matter, entire matter for disposal if both, if all the parties. Because where is your affidavit for Dusty? Affidavit filed on 27/3. Okay, sufficient time. They have not appeared.
No, madam. Well,
Just a
Yeah,
minute,
yeah,
please.
madam.
Just a minute. Here, Moririba.
Moririba.
Okay, what is your case?
Well, the petitioner is my lord. Is a selection grace, my lord, Arunachal Pradesh Forest Service, my lord. And the respondent is my lord, Arunachal Pradesh Forest, in the grade of Arunachal Pradesh Forest Service, entry grade, and is on probation, my lord. And
You are what? You are?
selection grade, my lord, Arunachal Pradesh Forest Service, selection grade, my lord.
And the respondent number?
Is Arunachal Pradesh Forest Service.
Respondent number 3.
3, my lord, is a entry grade on probation, my lord. Probation for 2 years, my lord. At the relevant date of passing of the impugn order, my lord, he was a probationer, my lord, and his service was not confirmed, my lord. By a transfer order dated 14/2/2024, my lord, lordship will kindly see at page 26, my lord. The petitioner was
You are Moririba?
Moririba, my lord.
Petitioner, okay.
My type copy lordship will find at page 27, my lord.
Yes.
I was transferred, my lord, Moririba, no, my lord, please, page 26, my lord, Moririba, my lord. DFO Meha Wildlife Sanctuary, rowing, to page 26, my lord.
26.
On to my DFO, Divisional Forest Office, Sagale, Forest Division.
From
14/2/2024.
DFO Mehao
Meha Forest Division, Wildlife Sanctuary, rowing,
to
to
DFO Sagale.
DFO Sagale Forest Division.
Yes.
Thereafter, my lord, I have joined at Sagale, my lord, on again by a transfer order dated 8/11/2024. I was transferred from Sagale to Bandardua Forest Division.
8/11/24.
8/11/2024.
Page?
11, page 27, my lord. From Sagale Forest Division to Forest Division Bandardua. And accordingly, complying this order, my lord, I have joined on 13/12/2024. My lord will find at page 29, my lord.
Joined when?
Joined on 13/12/2024.
13/12.
12, my lord.
You joined at Bandardua.
Bandardua, my lord. By a modified transfer order dated 24/12/2024 at page 30, I I was retained at Sagale, from where I have been transferred to Bandardua.
24/12/2024
in partial modification of order dated 8/11/2024. I was retained at Sagale despite my joining at Bandardua. And by the said order, respondent number 3 at serial number 15, page 31, my lord. He was, my lord, page 31, my lord. Serial number 15.
Which one number?
3, my lord. Goba Doke, assistant conservator of forest, is an entry grade, my lord. Was serving as a central mobile squad, Pasigat, to transfer to DFO Bandardua Forest Division, Vice Sri T.T. Topo in partial motivation of this order dated 8/11/2024, my lord. And the T.T. Topo, Lordship will find at serial number 19, my lord. He was retained there, column, my lord, remark from last column. He is retained there till 28/2/2024-25. That is the date of his retirement, my lord. 4, my lord, respondent number 3, my lord. His transfer order will come to effect only after 28/2/2024, my lord. The date on which, my lord, T.T. Topo will retire, my lord. Well, I was transferred to Bandardua. This was modified by this order, and one respondent number 3 was posted, my lord, against one T.T. Topo, my lord, who wished to, my lord, retire on 28/2/2025. If the result is being that, my lord, T.T. Topo will retire on 28/2/2025. This is the only reason for, my lord, accommodating the private respondent, my lord, which cannot be, my lord, so, my lord, cannot be in a public interest, my lord, because I have already joined there at Bandardua, my lord. And I was sent back to my earlier place of posting at Sagali, my lord. And, my lord, Goba Doko was promoted to the post of, my lord, APF entry grade, lordship would find at page 35, my lord. May I read, my lord? On the recommendation of the Departmental Promotion Committee held on 2/2/2023, Governor of Arunachal Pradesh is pleased to promote following range officers to the post of ACF entry grade of the Department of Environment and Forest in a level 10 pay matrix plus other earnings as admission from time to time with probation for a period of 2 years.
But he was promoted.
Yes. Rule says, my lord, even for promotion, my lord, they have to under promotion for 2 years, my lord. I will come to that rule, my lord. The date from the date of.
So what is page 35?
My lord?
What is this page 35?
This is promotion, my lord, and he was placed under probation, my lord, for a period of 2 years, my lord. Last line, my lord. Probation for a period of 2 years from.
Where page?
Page 35, my lord. The first paragraph.
Yes.
Last line, my lord. May I read again, my lord? Last line. Is admissible from time to time with probation for a period of 2 years with effect from date of DPC, that is 2 February 2023. In the cadre of APFS. Serial number 3, my lord. Well, here I would like to show that, my lord, he is still under probation, my lord.
But probation not as an entry grade officer. Probation as.
Entry grade officer, my lord.
No.
ACF, my lord. ACF is a assistant conservator of forest.
Following force. Oh. Okay.
My lord,
From RFO to ACF.
ACF, my lord. My lord, in the bracket, it is also shown that entry grade, my lord. And the rule has their own schedules, my lord.
And you are DCF.
I am, yes, my lord.
DCF.
DCF, my lord. Senior grade, my lord. My lord, to my respectful submission, my lord, under the rules, my lord, the respondent number 3 could not have been, my lord, posted to, my lord, Bandardua Forest Division, my lord. While his, my lord, service is yet to be confirmed under, my lord, rule, my lord, Rule 24 of the Arunachal Pradesh Forest Service Rules, my lord. Confirmation has to be done by a DPC, my lord. Then only, after confirmation only, my lord, he will be treated as a Arunachal Pradesh Forest Service officer, my lord, in the entry grade, my lord. My lord, kindly, my lord, there I filed a representation, my lord. Lordship saying that, my lord, it violates the transfer order, violates the rule, my lord, posting of the respondent number 3, my lord.
When did you file representation?
Representation, my lord, was filed on, my lord, 31/12/2024, my lord. Page 31/12/2024, my lord. Page 47, my lord. Saying that, my lord, in violation of the rules, my lord, he was posted, my lord, at Bandardua, my lord. My lord, while the matter was listed, my lord, my lord, in the first round of writ petition, my lord has occasion to address, my lord, gone through the writ petition, lordship, at page 50, my lord.
Yes.
Has some observations, my lord, at page 50, my lord. Second paragraph onward, my lord. It is projected case of the petitioner that on 14/2/2024, the petitioner, who is in the rank of the divisional forest officer, was posted in Forest Sagali division. The petitioner has accordingly joined at Sagali. Thereafter, on such instance, he was transferred to Bandardua Forest Division, which he had joined on 13/12/2024. However, by the impugn order dated 24/12/2024, petitioner has been sought to retain at Sagali in his place. Respondent number 3 has been sought to be transferred from Pasia to Bandardua. The petitioner has also raised the
Yes,
contention,
we have read.
my lord,
So
and
we have
accordingly, my
directed
lord,
status quo.
directed status quo, my lord, and directed to, my lord, produce, my lord, get the instructions, my lord, on the next date, my lord. On the next date,
This
my
was
lord,
in another writ petition.
my lord. Then in on that date, my lord,
No,
next
you
date,
had
my
earlier filed another writ petition.
yes, my lord.
WBC
58 of 2025. Lords will find at page 52, my lord. It was when the instruction was not forthcoming, my lord. This honorable court has disposed of the, my lord, the writ petition, my lord, with a direct. Lords will find at page 52, my lord. To, my lord, page 55, my lord, operative part, last paragraph, my lord, to dispose of the writ petition, my lord, representation, my lord. Paragraph 9, my lord, situated thus, in view of the submission made at the bar, this writ petition is being disposed of by directing the respondent authorities to consider the representation dated 31/12/2024 submitted by the writ petitioner and dispose of the same by a written order within a week from today. Whatever be the decision in the matter, the same shall be communicated to the writ petitioner till such time representation status quo as on date as regard to posting of petitioner and private respondent shall be maintained. My lord. It is finally, my lord, disposed of, my lord, by an order, my lord. Lords you will find at page 57, my lord. May I read the order, my lord? Because here, my lord, no reasons has been assigned why I was
Why is this finding at paragraph 8? Since the transfer order has not been modified or suspended
yes,
by any of the, there was an order of status quo.
there is an order of status quo, my lord. My lord. My lord, anyway, my lord, ultimately, my lord, the representation was disposed of at page 57, my lord, on 21/2/2025, my lord.
No, this is the disposal, page 55.
Page 57, my lord.
The representation.
After the, my lord, honorable court's order, my lord.
Representation.
Yes, my lord. My lord, The representation was disposed of, my lord.
Order dated?
My lord, they have, nothing has been said about the,
21.
my lord, retention and the transfer of, my lord, the respondent number 3, my lord. Only by citing some Supreme Court judgments, it was disposed of, my lord. May I read, my lord? Paragraph, my lord, 5 onwards, my lord. Whereas Mori River DCF has also filed a writ petition number such and such before the Honorable Party High Court Eternal Bench, which entirely praying for grant of stay of the transfer order and allow him to relieve TT Tapu DCF on his superannuation retirement with effect from such and such by restoring the order dated 8/11/2024. Whereas Principal Chief Conservator of Forest and Head of the Forest Force is arranged as respondent number 2 in the writ petition. Whereas Honorable Court on 14.
Yes, I have read this.
My lord. And next page, my lord. The reasons, my lord, given, my lord. The whereas Sagali Bandharwa Forest Division are two similar territorial forest divisions under the Department of Environment Forest, Arunachal Pradesh, and employees should therefore not claim any preference of one over other contrary to the orders of the government in public interest. This is the only reason, my lord. My lord, while I was transferred from Sagali to Bandharwa, it is not on my instant that I have requested the, my lord, government, my lord. It is, they have decided to transfer me, my lord, to Bandharwa, my lord. And no reasons has been given in this, my lord, speaking order, why he has been posted, my lord, at Bandharwa, my lord, in violation of the rules, my lord, because his service was not confirmed, my lord. And why I was retained at, my lord, Sagali, my lord. This has not been dealt with by this speaking order, my lord. Now, my lord, the schedules of the, my lord, the rules, my lord.
Yes.
There are 3 categories, my lord, under the, my lord, Arunachal Pradesh Forest Service rules, my lord.
Page.
My lord, category, my lord, also before the, my kindly read the, my lord, rule, my lord, 3, sub-rule 2, my lord. At page, my lord, 36, my lord. Rule 3, my lord. Constitution of service and its class.
What are the name?
Rule 3, sub-rule 2, service shall have the following
What
4.
is the name of these rules?
My lord, Arunachal Pradesh Forest Service Rules 2019.
Yes.
My lord, there are, my lord, 4 categories of service, my lord. In this. Rule 3, my lord, sub-rule 2, my lord. There shall be following 4 grades, namely entry grade. Entry grade is the ACF, my lord, the respondent number 3. Senior grade, selection grade, administrative grade, my lord. And my lord, after that, my lord, again come back to my lord, section 3, subclause H, my lord. The confirmation of the probationers, my lord. Same page, my lord. Rule 2, my lord.
2H.
2H, my lord. The Departmental Promotion Committee oblique Departmental Confirmation Committee means a committee constituted to consider promotion and confirmation in any grade as specified in the Schedule 1, my lord. And my lord, therefore, my lord, kindly see, my lord, Rule 24, my lord. Page 41, my lord. Rule 24, my lord. Confirmation of service, my lord. 41. A person who has been declared to have satisfactorily completed his or her probation period may be confirmed in his service by Departmental Promotion Committee prescribed under Rule 14, my lord. Rule 14, my lord, is includes, my lord, departmental promotion committee, my lord, confirmation of committee, my lord. My lord, thereafter, my lord, kindly again come back to, my lord, method of recruitment, my lord.
Page.
Page 37, my lord.
Yeah.
50% by direct recruitment, my lord, and 50% by promotion, my lord.
Rule 5.
Rule 5, my lord. Rule 5, sub 2, my sub clause 2, my lord. 50% by promotion, my lord.
Yes.
My lord has just seen the promotion order, my lord. They will be for probation for a period of 2 years, my lord. And he has not completed the period of 2 years, my lord. So, my lord, the schedules of the, my lord, again come to, my lord, schedules of the, my lord, post, my lord, page 44, my lord. At page 45, my lord, these are the post, my lord, C, my lord. These are the post earmarked for the, my lord, as a HS officer in the various forest division, my lord. Serial number 1, my lord. Bandodua Forest Division, my lord, is for the additional deputy conservator of forest, my lord. Earmarked for, my lord.
Where do you get?
At serial number 1, my lord.
Where do you get Bandodua?
Bandodua, my lord, additional conservator of forest, Bandodua Division, my lord. Serial number 1, my lord.
Okay, yes.
Having pay scale of such and such, my lord. And he was posted in this, my lord, category, my lord. And he ought to have been, my lord, he is, my lord, scheduled, my lord, poster, my lord, at same page, my lord, D, my lord. Last paragraph, my lord. He could have been, my lord, posted the post under assistant conservator of forest entry grade as attached officer in the various forest division. These are the posts, my lord, where he can be posted, my lord. And that too, my lord, only after, my lord, confirmation of the service by a DPC, my lord, as held under Rule 14, my lord, he can be posted in this, my lord, scheduled, my lord, place of postings, my lord. And, my lord, the authority has not, my lord, given any reasons, my lord, while disposing the, my lord, my representation, my lord. So, my lord, record is there, my lord. My lord, kindly produce record, my lord, whether there is any exigency of service, again retaining me back at Sagali, my lord, and posting respondent 3 in violation of the rules, my lord. First direction was to produce record on, my lord, is on 28.
Okay, yes, got it. That's all?
My lord.
We'll come back to if necessary, yes, Mr. Rama.
May I just take to your lordship first transfer order, my lord, that is 8 November 2024, my lord.
Yes, page 27.
Yes, page 27. The page 20 is the date, my lord, 8 November 2024. My lord, here, my lord, the petitioner, my lord, serial number 4, my lord. Now, before that, my lord, your lordship may kindly come to page 26, my lord. This is the first transfer order. 14 February 2024, my lord, first transfer order, my lord.
26.
14 February 2024, my lord, page 26.
Yes.
Mori River, my lord, Diapo, Meho Wildlife Sanctuary Rowing. So that is very important. Now, 14, then next again, my lord, he was transferred to Bandardoa, my lord. That is page 27, my lord.
That is 811.
Yes, my lord. Now, Mori River transferred to my lord Bandardoa. Then Duge Basar, my lord, Kurunkabe Forest Division to Sagale. These are two cross transfer, my lord. Your lordship may kindly mark, my lord. 4 and 5. The 5 is to replace 4, my lord, and 4 will come down to Bandardoa, my lord.
Is 20?
27, my lord. From 2, my lord. Serial number 4, Mori River, DFO Sagali Forest Division. Then 2, DFO Bandardoa Forest Division. By Titi Tapu transferred. Then second is, my lord, Doge Basar, SFS, DFO Kurunkame Forest Division, transferred to DFO Sagali Forest Division. So in his place, my lord, Doge Basar is to join there, my lord.
Correct.
Then, my lord, this transfer was not given effect to, my lord. This transfer was not, my lord. Especially this 4 and 5, my lord. 4 and
But
5.
he said that he had joined.
My lord, I'll demonstrate, man, how he can join, my lord. He cannot join there, my lord.
You said that the second transfer order was not given effect to.
Yes, my lord.
811.
811. Now, my lord, this page 29, the petitioner has said, man, he has joined on 13/12/2024, right, my lord?
Just a minute.
This is the joining report, my lord.
13/12, yes.
Yes, my lord. It's addressed to whom, my lord? To the Divisional Forest Officer. The address itself is wrong, my lord. There is a conservator of, my lord, CCF is there, Chief Conservator of Forest, my lord, who is heading the division, not by the DFO, my lord.
A copy has been given to, my lord, the concerned authorities, my lord.
Okay, welcome. Welcome.
Then that is very important, my lord. 13/12/2024. Right, my lord?
Yes.
Then when Mr. Titi, my lord, Tafu retires, my lord, he retires on 28/2/2025, my lord. How he can join there, my lord? The DFO is already functioning there, my lord. This man retires only 28/2/2025, my lord. I can just demonstrate, my lord, if your lordship see, my lord. Page 31, my lord. Has your lordship got?
Just a minute. You said that firstly, this joining report has not been given to the appropriate authority.
Yes.
Number one. Number two.
Number 2, my lord.
He could not have joined because Tapu was already in service.
Yes, my lord. He retires only 28/2/2025, my lord. Now, how can the petitioner join 2024, my lord?
28/2/25.
Yes, 28/2/2025, my lord. Yes. Now, how he can join on 13/12/2024, my lord? Then another point, my lord. Now, when he joins, my lord, there must be receipt, my lord. And if your lordship peruse, my lord, there is no any acknowledgement from any authority, my lord. Totally blank. Maybe, my lord, this is self-made, my lord, joining report, my lord. Maybe manufactured, I can say that, my lord. There is no any receipt by any branch, my lord. Now, my lord, again he has said, my lord, now the petitioner claims to be, my lord, selection grade. No, my lord, that is wrong, my lord. He is in senior grade, my lord, not in selection grade. That also I can demonstrate, my lord. Now, petitioner is, my lord, this year, my lord, There is no any doubt about that, my lord. Yes, I can demonstrate, my lord. Your lordship may kindly come to page 36, my lord. This is the recruitment rule, my lord, for Forest Service Rule 2019. If your lordship come to my lord, 3, my lord. Rule 3, my lord, yes. The constitution of service and classification. The number 2, my lord. The service shall be following 4 grades, namely. Number 1 is entry grade, my lord. Entry grade means ACF, Assistant Conservator of Forest. Now, senior grade, obviously it will be DCF, my lord, the petitioner, my lord. Now, how he can claim that he is a selection grade, my lord? Selection grade, if I not wrong, it should be CF, my lord, Conservator of Forest, my lord. And he is a DCF, my lord. He is not a CF, my lord. So that's why I think this is not correct statement. If the other say,
No, in the order itself, he has been shown as DCF only. There's no.
DCF, my lord, that's why, man, he cannot say that he is a selection grade.
Now, how will it make a difference? Even if it's a senior grade or selection grade.
My lord.
One of his limbs of argument is that the private respondent is
Private
not-
respondent is just, my lord, ACF, my lord, he is entry grade and he is in selection grade, my lord.
No,
That
no,
is
no,
the,
forget the selection grade. He's a DCF.
my lord, DCF, right. Now, my lord, this particular, my lord, Bandardua, my lord, this DFO, this has been notified only for the IFS officers, my lord. Indian Forest Service, my lord. This was especially notified for that. In case of any shortage of, my lord, manpower, then, my lord, APCS officers, my lord, they are APCS. So it is very wrong to say that only the selection grade or, my lord, the senior grade, they are entitled to hold this post. No, that is wrong, my lord. Now, my lord, both the grades, my lord, entry grade and, my lord, the senior grade, they are entitled to hold this post in case of emergency, if there is no manpower or IFS officer is not available. They are allowed to hold this post. Not only in this case, my lord. Many times, my lord, due to shortage of officer, we allowed to hold, my lord, APCS officers.
But was there a shortage of officer? The petitioner was there.
He never joined here, my lord. I have shown, my lord, how he can join, my lord. Mr. Tapu was not retired, my lord. He
No,
request,
now he wants to where? He is challenging what? He wants to come where?
my lord, he wants to come to, my lord, Bandradua, my lord. That's why, my lord, if your lordship see subsequent orders, my lord, your lordship will find, my lord, he remains Sagali itself. Your lordship will never find that he has been retransferred from Bandradua to Sagali. Because he never joined here, my lord, Bandradua. That is the reason, my lord, why it has been said he has been retained at Sagali, my lord. If your lordship see a subsequent order, my lord. Page 30, my lord. Has your lordship got it? Page 30, my lord, 30.
113.
Yes, my lord. Serial number, my lord, 12. Mori Riva Mali is the petitioner, my lord. Arunachal Pradesh Forest Service, APFS.
Page 13, not 13, 30.
30, my lord.
30.
30. Serial number 12, my lord.
Just a minute, please. Serial number 12, yes.
Yes, my lord.
Petitioner.
Petitioner, Madam Mori Riva, Arunachal Pradesh Forest Service, DFO Sagali Forest Division, from 2, my lord, DFO Sagali Forest Division, in remark column, your lordship find retain as DFO Sagale Forest Division in partial modification of this office order dated 8/11/2024, my lord. Retain, my lord. It never says he has been retransferred from Bandura to Sagale. No, my lord. Then, as I've said, my lord, this was the cross transfer between my lord Mori River and Duge Basar. Even Duge Basar was written in the same place, my lord. If your lordship sees serial number 13, my lord.
Okay, sir, yes.
Yes, my lord. Duge Basar, Arunachal Pradesh Forest Service, Duge Basar Kurung Kambe Forest Division, same my lord Kurung Forest Division, written as DFO Kurung Kambe Forest Division. So both these officers were written in the same place, my lord. That's why I've said, my lord, the earlier order was not given effect to, especially for these two officers, my lord. So they remain in the same place, my lord. This shows, my lord, the petitioner never joined or assumed the DFO of Bandardua, my lord. Otherwise, transfer order could have said, my lord, retransfer from Bandardua to Sagale, my lord. That is the reason, my lord. Now, my lord, coming to, my lord, this probationary period, my lord, completion of 2 years. That exactly my friend is my harping on 2 years. Now, if your lordship see, my lord, Departmental Promotion Committee, this DPC recommendation, page 35, my lord. Because that will be very important, my lord.
Yes.
My lord, that is, my lord, probation for a period of 2 years. That is with effect from 2nd February 2023. This is very important.
Yes.
Then when, my lord, 2 years completes, my lord, 2nd February 2025, right, my lord?
25, yes.
Yes. Then when Mr. T.T. Tapo retires, same period, my lord, same month, my lord. Your lordship kindly see the dates, my lord. Your lordship may kindly come to page 31. When Mr. T.T. Tapo
28,
retires.
28,
28 February, my lord. 28 February, my lord, 2025. Then, my lord, the private respondents, my lord. He completes, my lord, 2 years on 2nd February 2025, my lord. Right, my lord?
Yes.
So that way, my lord, he completes, my lord, 2 years, even probation period, before joining, my lord, this Bandardua. Because he could have joined only after, my lord, 28th, my lord. He cannot join prior to that. Till then, Mr. Tapu will be holding the charge, my lord. So that way, it's not correct to say that he has not completed 2 years of probation period. That is not correct. Now, coming to, my lord, representation, the disposal, my friend has said, my lord, there is no any observation or justification given, my lord. My lord, now this DF under, my lord, Bandardua division, my lord, is headed by the CCF, Chief Conservator of Forest. Now, under this Chief Conservator of Forest of Bandardua Circle, there are 11, my lord, divisions are there, my lord. If I correctly remember, my lord. 11 my lord, divisions are there, and one is, my lord, Sagale division. And one division is Bandardua itself, my lord. It's a circle, but they have a division, my lord. Now, under this Bandardua circle, my lord, if I correctly remember, even the Pakekeshan, the Sapa, the entire divisions, they are under this circle, my lord. Eastern or Western circle, they call it, my lord. Now, Sagale, my lord, DFO and Bandardua DFO is, my lord, is the same, my lord. Is same, my lord, because it comes under the conservator of this forest, my lord, under this circle, my lord, Bandardua circle, my lord. But there is admittedly, my lord, even the record it says, my lord, this DFO because it's placed in
No, you
import,
said that the Bandardeva circle
my lord,
has got 11 divisions,
divisions, my lord.
including Sagali and Bandardeva.
Yes, my lord.
These are separate divisions.
My lord, divisions are separate, but within the same circle, my lord. There is a
Circle is same.
Circle
Yes,
is
yes.
same.
So if it's a separate division, it has to have separate divisional forest officers.
Correct, my lord. Correct. So under this circle, there are 11 forest divisions are
Yes,
there.
yes.
Yes, my lord. Now it cannot be say, my lord, the Sagali division higher, my lord, the Bandar division lower. No, it's wrong, my lord.
No, he has not said so.
My lord, he has said, my lord, the senior should hold the post of my lord Bandardua, junior should hold the post of Sagali. That he indicates, my lord. Because he said, my lord, because the private respondent is my lord, entry grade, my lord. He is in entry grade and he is in selection grade, my lord. This shows my lord, senior and junior, my lord. My lord, senior should hold the post of Bandardua and junior should hold the post of Sagari, my lord. That's what my friend wants to murder project, my lord.
But this order at page 35
My lord,
of the private respondent,
this is a promotion order, my lord.
promotion order, promotion from which post to which post?
My lord, this is reserve range forest officer to my lord
To ACF.
Huh?
To ACF.
ACF, correct, my assistant conservator forest, my lord.
Whereas the petitioner is
He's a
the
deputy conservator forest. my lord.
deputy.
Correct, my lord.
So one post above.
No doubt about that.
Your argument, if you even accept that before 28 to 2025, that promotion period also is over.
Over, my lord.
But he becomes a regular member of the ACF cadre.
Correct, my lord.
He'll not be a DCF.
My lord, correct. And there is no bar, my lord, that the ACF cannot man the post of my lord DFR. If my friend
there
told
is-
my lord said that
Since you are exercising certain powers
My
of
lord.
retaining the petitioner at Sagali, let us accept your submission for the time being. There is no transfer, he was retained,
my lord.
but there was a conscious order. What prompted you to pass the order?
Which one, my lord, from Sagali to
Not to
Bandar?
retain him at this Sagali and post the private respondent at Bandarjeeva.
Number one, my lord, he hardly completes the 8 months only, my lord, from Rohing to Sagalit. Number one point could be, my lord. He has not completed the normal tenure, my lord. Because somewhere in February 2024 only, my lord, he was transferred to Sagali, my lord, from Rohing. Then November, 8 November, again, he has been shown to be transferred from Sagali to Bandarjeeva division. So within a spell of 6-7 months, my lord, say maximum 8 months, my lord. That could be one reason. The second reason could be, my lord, because Mr. T.T. Tapo retires only 28 to 2025 only.
So what about then allowing this petitioner to hold the post after 28 to 2025 when Mr. Tapo would be retiring?
My lord. Then, my lord, then Sagal will be vacant, my lord.
No, he was already transferred from Sagali to Bandardeva.
No. He cannot be, my lord. That's why I've said, my lord, because Mr.
Now, what about page 27? Whether he has joined or not, it's a different matter. But page 27
My lord,
is an order by which
my lord, page 27,
Yes.
this order was passed, my lord, without taking consideration of Mr. T.T. Tapo retires only
Understood.
28, my lord, 2025, my lord.
Okay.
That could be number one reason. The second reason, my lord, he has just completed 6 or 7 months in Sagali Forest Division, my lord.
So why did you pass this order of at page 27? If you knew that he had just completed 7-8 years months at Sagali,
That's why, my lord, this order was not given effect to.
where is the order of not giving effect to? That you cancel the order.
My lord, your lordship may kindly come to page 30, my lord. This is the fresh order, my lord.
Yes.
Serial number 12, my lord, the petitioner. He's been retained at Sagali, my lord. Then same, my lord, serial number 13. This man also retained at Kurun Kame, my lord.
From 8/11/2024, you passed the second order on 24/12/2024.
Yes.
That is more than 1.5 months.
More than 1.5 months. Correct.
And you say that his joining report, though it is on record, that does not bear any acknowledgement. So he has not joined at Bandadwa.
Man, he cannot, man, why I've said, man, because Titi Tapu returns only, man, 28, 2025, man, how he can join in 24, man? He cannot, man. And so for private respondent is concerned, man, he only joins, man, after the retirement of Titi Tapu, man.
You know, why a similar stipulation could not have been given to the petitioner?
My lord, the region could be, region is, my lord, of course, record to the reveals. The number of region, my lord, if it allows, my lord, to join after this 28 2025, my lord, then, my lord, the Sagali, my lord, division falls vacant, my lord.
No, this person can be taken to Sagali.
Sagali. Then secondly, my lord, as I've said, my lord, the Bandar division, forest division, especially is notified for IFS officer. Now, this is just a temporary arrangement, my lord. Once IFS officer available, he'll be replaced, my lord. This is just a temporary arrangement.
No, even the petitioner can be replaced once.
Obviously, that can be said, my lord. That can be said.
That will not be
but-
an argument.
but-
That argument will not stand.
But
Temporary post, let him face the music, let the petitioner go to Sagali. That is not acceptable. But what you are trying to say that within a very short period of time, he was brought from Sagali to
Bandadua, my lord.
Bandadeva, and that was not never given effect to. He
My
remained at Sagali.
My lord.
So by the order at page 30, you retained him at Sagali.
Absolutely.
That is what is
Correct, man.
Well, let us see the record. Anything else before you pass over the records?
Before my lord, first,
We will come to you. Let him complete.
My lord, records, my lord, of course, index or context they have given, my lord. And my lord, lastly, my lord, since my lord, both the divisions comes under the same circle, so my lord, petitioner should not be allowed to choose the place, my lord. And Sagali and Bandar is also not so far also.
How far is Sagali from here?
Hardly it will be within 25 kilometers maximum, not more than that.
Sagali is towards which?
Sagali, my lord,
zero side?
via zero side. Yes.
Zero side, yes.
One is to divert left
Sagali
side.
is only 25 kilometers.
more than 100 kilometers.
Sorry, not more than 100, my lord. Even my lord, zero is 98 or 75.
105.
Zero, no, from here is
It may around 95 kilometers or 90 kilometers maximum
98 something like
from UPR.
Yeah,
From
not-
Naharlagun is 105.
Yes. When you say that that junction, that there the signboard is so small is 98 kilometers, my lord. So Sagal is more nearer than zero, my lord. So it will be around 70 to 80 only. Not even 100 miles.
Not 25.
Not 25, I'm sorry, not 25, my lord. That's my submission, my lord.
Okay.
My lord, my lord, my friend has said that, my lord.
AAG has demolished your case. We thought you had a case.
My lord, my friend has said that, my lord, the transfer order dated, my lord, 8/11/2024 cannot be given effect as because, my lord, the one, my lord, TT Tafo
Was still
was
holding the
that post, my
till
lord.
28 to 2025.
He used to return only in the last part of the February, my lord. My lord,
As of now, okay, Mr. Welcome. Mr. Who is holding the post now?
Right now, my lord, the private respondent is assumed, my lord, is discharging the duty, and petitioner Mali is happy. I think he is happy in the Sagale Mali. He also went back and he discharged his duty from Sagale.
Where are you?
In
Sagale.
Sagale, my lord.
Sagali. Happy at Sagali?
no, my lord.
Not happy, unhappy.
That's why I filed a writ petition, man. I will clarify one.
No, that time the situation was different. Now you must have adjusted at Sagali.
Well,
Very nice place.
Nice place.
my
Better
lord,
than Bandadua. No hustle and bustle. You get pure air and water.
my lord, while I was transferred at Bandodua division, my lord, against one vice TT Tapu, my lord. My friend has said that, my lord, he will be returning only on 28 to 2025. So how I can be posted there, my lord? In the same transfer order, my lord, he was, my lord, attached to, my lord, page 27, my lord, serial number 6, my lord, kindly see, my lord.
Yes.
Muririba, my lord, serial number 4, DFO Sagali to Bandradwa Forest Division, Vice Sri TT Tapu transferred, my lord. He was transferred, my lord, from Bandradwa Forest Division, my lord. My lord, to my lord, CCF, Office of the CCF, WSE, my lord, Western Arunachal Circle, Bandradwa, my lord. It's only the vacant, my lord, by this transfer order, my lord. He was, my lord, the DFO Bandradwa, by the same transfer order, my lord. He was attached to my lord CC Office of the CCF, Bandradwa, Western Arunachal Circle, Bandradwa, my lord. And I have joined, my lord, transfer to the transfer order, my lord. As shown the, my lord, joining report. Copies were given to the, my lord.
Joining report does not have any acknowledgement.
My lord.
Mr. Nabam is harping.
My lord, the record, in the record it will be there, my lord, I think, my lord. If I have really submitted joining, my lord. Then, my lord, another, my lord, aspect, my lord, my friend has said that, my lord, I am not a selection grade employee, my lord. But kindly see page 32, my lord.
What is WSC West?
West Arunachal Circle, my lord.
Yes.
My lord, my another contention is raised by the my learned friend that I am not holding the grade of selection grade, my lord.
Senior.
Senior.
Yes.
And I am a senior grade, my lord, which is not correct, my lord. My lord, kindly see, my lord, page 32, my lord.
32.
My lord. The first echelon, my lord, the highest echelon of the service is, my lord, the admin grade, my lord. And my promotion is due, my lord. May I read, my lord? Appointment by promotion to the post of Arunachal Pradesh Forest Service Administrative Grade, Selection Grade, Senior Grade, Entry Grade, my lord. And my lord, for admin grade, my lord, my promotion is due, my lord. Last paragraph tabulation, my lord. Serial number 6, my lord. My promotion to the, my lord, admin grade is due, my lord. And for promotion to the, my lord, admin grade, my lord, the rules, my lord, 33, page 31, my lord. Rule 33, my lord, kindly peruse, my lord, for a moment, my lord. The appointment rule, page 43, my lord.
43.
My lord. Page 43 is the appointment to the my subject, my lord. Is appointment to the, my lord, Forest Service Administrative Grade, my lord.
Yes.
Appointment of the members of the service of the admin grade shall be made by promotion on selection grade on the basis of recommendation made by the DPC, the composition of DPC successor, and officer with a minimum 5 years of regular service in the grade in the selection grade, my lord, shall be eligible for being considered for promotion to the admin grade, my lord. I am selection grade, my lord. And my lord, for the, my lord, where he has been posted at Bandradwa Division, my lord, he is admittedly a, my lord, assistant conservator of forest, entry grade, my lord. To become a selection grade, my lord, rule 31 says, my lord, page 42, my lord. From ACF to, my lord, senior grade, my lord. Appointment of rule 31, my lord, appointment to the Arunachal Pradesh Forest Service, senior grade. The appointment of the members of the service in Arunachal Pradesh Forest Service, entry grade, who is possesses graduation bachelor degree in science, forest from recognized university, shall be considered for promotion to the Arunachal Pradesh Forest Service senior grade on completion of 5 years of regular service in the Arunachal Pradesh Forest Service entry grade, including 2 years period of training in the state, my lord. So, my lord,
You are reading 31.
31, 1, Roman 1, my lord. For him to be promoted, my lord, to the post of, my lord, in the grade of selection, senior grade, my lord, he needs, my lord, 5 years of regular service in the grade of entry assistant conservator of forest, my lord. And he was given posting to a place, my lord, where, my lord, the posts are earmarked for the senior grade officers, my lord. And regarding another aspect, my lord, my submission made by my learned friend, that he will be completing the, my lord, probation, my lord, in the month of February, my lord. After the retirement of Tapu, my lord, 28/2/2024, so there is no wrong in giving place of posting at Bandardua, my lord. My lord, his entry grade survey promotion, my lord, has to be confirmed by a DPC under Rule 14, my lord. On successful completion of the probation period, his, my lord, case will be considered for entry in the forest service, my lord, by a DPC, my lord, under Rule 14, my lord. And till that, my lord, to my lord, information, my lord, his, my lord, probation has not been confirmed by a DPC, my lord. So my humble submission is that, my lord, the posting of the respondent number 3 is in violation of the rules also, my lord.
You are not citing that the day before yesterday, the last week, this was cited that Hibu case.
Hibu Tama, my lord.
Hibu Tama.
My lord.
Where is that case?
My lord, before that, if your lordship come to my lord, because my friend, he was
Justice
referring
Tagia, then one judgment, earlier judgment of Justice Bhuyan.
Justice Buya, then second name is Justice Tagia, my lord.
Yes.
May I just take to your lordship to page 31, because my friend is relying on 32, my lord.
No, one second, we'll come to
My
you.
lord.
Anything else?
My lord.
You get that decision,
My lord.
Hibu Tama. Justice Tagia's decision.
But
Yes.
in that case, my lord, facts are different, my lord. Because if I correctly remember that passed by my lord Justice Tagia, wherein my lord, similarly, my lord, situated officers were available, my lord. Ignoring that, my lord, officiating was given charge, my lord. In that case, my lord Justice Tagia said that it should be, my lord, if the person is not holding the same cadre, he should be replaced by some other, my lord. Under that circumstances, my lord. And here is different, my lord.
Why it is different? You have a person who is a DCF,
My lord.
who is eligible to hold that post at Bandardua. Rightly or wrongly, there was an order of his transfer to Bandardua from Sagali. And the person in whose place he is to be replaced, that person was to retire on 28/2/2025.
Right, my
But the said order also said that to accommodate the petitioner, he is transferred and attached to the post of West Arunachal Circle.
My lord.
That arrangement
My
was
lord,
there.
if my friend can, my lord, substantiate that Mr. Tapu, my lord, assumed the duty, as my lord said, my lord, that he has been transferred out as a DFO Bandura to some other, my lord, even that was also not acted, because my lord, request was made to the government that he should retain that post till 28th, my lord. That was accepted, my lord. Because of that only, my lord, no one, even the petitioner, private respondent, could not have, my lord, joined prior to, my lord, 28th February 2025, my lord.
This West Arunachal Circle, is it a different office or what?
I'm sorry, my lord.
The West
Bandardua
Arunachal
itself, my lord.
Circle, is it a different office?
Different office, madam. Is it headed by CCF of CC?
My lord, it's a circle wise, my
but
lord.
when the 8/11/2004 order, 2024 order.
8/11.
Yes. At page 27.
Yes, my lord.
After the order of the petitioner, you have TT Tapu also?
Yes, my lord.
Next serial number, page 27.
4, 5, and 6, my lord.
Kindly come to Tapu's order.
Tapu's order, my lord.
Yes.
Yes, my lord. TT Tapu,
Yes.
AFS, DFO Bandar Forest Division, attached officer, care of CCF, then Western Circle.
West Arunachal Circle.
West Arunachal
So
Circle.
where is this office from the original office?
It's a Bandar itself, my same, my lord, same.
So the consideration that he was in the verge of retirement,
my lord,
will not serve any purpose. He is not required to shift anywhere.
My lord. Right, my lord.
The subsequent document which
My
we
lord.
had placed reliance that this Topu was on the verge of retirement, we considered you retain him in the same office.
My lord,
By the impute order, he was not required to shift anywhere.
not at all, my
The
lord.
verge of retirement is only because the family should not suffer
Correct,
of
my lord.
shifting their residence. But he is from in Bandadu, one office to the other office.
Yes.
So there is no question of any shift.
No, no shift, my lord.
That is why we were asking that whether West Arunachal Circle is a different office.
No, my lord, same, my lord, same.
Bandadu only.
Same, my lord, yes, my lord. It's headed by the CCF, my lord, Chief Conservator of Forest, my lord.
The setup will be slightly different, maybe one
Well,
office to the other office, but
absolutely.
the location is the same.
My lord. Now, my lord, if my friend can, my lord, produce any document, my lord, beside the joining report without saying the signature, that he has assumed the duty of Bandadu as a DFO, my lord. If he can show any document.
But
that-
the order by which the representation has been disposed of,
My lord.
you had taken up so many points, which are valid points. We may agree, we may not be agreed, but these are points we have to consider.
My lord.
But what are the points taken up in the representation? The
Representation, my
person
lord.
who had applied his mind, how he has disposed of the representation? He has quoted one Madras High Court, maybe he's come from Madras. So very easy for him. One Madurai bench decision,
My
and that is the sacrosanct law for him.
My lord. Could have been, my lord, better
And what is the
explanation.
point involved there? In the Madras High Court? Reboot আমার বলে এটা তো বেলেগ দেখলাম না Kindly have a look at this. This is Amar Godo. We had passed one order the other day following Hibutama. Both of you kindly have a look. This was recently passed
yes,
last
ma'am.
week by this court. Just turn over the pages. We had relied upon Hibutama. It was the last. Have you got bold letters Hibutama?
Yes, my lord.
GLT, I think.
Yes. My lord, when this matter was heard, my lord, first time, even my friend, my lord, he was referring all these things, my lord. But when we demonstrated that both DFOs are same, and when you saw the notification that this bundle the DFO especially meant for my lord IFS officer, my lord, and because of exigency, we allow the Arunachal Pradesh Forest Service officer to meet for the timing, my lord, not for a permanent. As when officer available, will be shifted out. And my lord, the similar, my lord, the matter before the division bench, my lord. Intra-court appeal is there, my lord. I believe, my lord, subject to your lordship correction, these are the not correct law laid down by my lord Justice Tagia, because facts have to be seen first, my lord.
But there is an earlier order of Justice Bhuyan.
Yes, my lord. First with my lord Justice Bhuyan, then that was followed by Justice Tagia, my lord, my lord. The facts has to be seen, my lord.
That is the coordinate bench, so we are bound to follow.
Then, yes, my lord. But my lord, in the case of my lord, that Urban Development Department, my lord Justice Surana, my lord, he tried to, my lord, distinguish based on, my lord, facts and circumstances, my lord. Because if, my lord, regular employee is not available, then, my lord, under that what circumstance, what we can do, my lord? We have to accommodate someone to mean that post.
You definitely have to run the show, but should not be to the prejudice, legal prejudice of any person who is eligible.
My lord, if officers are available, ignoring that, if we are accommodating some juniors in that counts, yes, your lordship is absolutely correct, my lord, yes.
But if there is an exigency, there is no officers available.
My lord.
Then you bring somebody, then nobody will be agreed.
My lord.
Some stranger cannot raise this issue.
My lord.
But one who thinks that he has a right to be considered.
But in that Himutama case, what happened, my lord, that is power department, if I correctly remember. Regular, my lord, superintendent engineer was replaced by, my lord, officiating executive engineer. Recently, he was given the holding post and subsequently he was transferred there. Now. In that count, my lord, Tagia said, no.
Even our this order which we had passed the other day.
My lord.
it
Maybe
was
same
also
thing happened, my lord.
yes.
My lord. In that
He was
count,
not
yes,
even in the cadre.
my lord. Not only cadre based, my lord. Suppose
No, it was a lower cadre. He
my
could not
lower
have-
cadre, my lord. Now, if you strictly follow this cadre basis, my lord, that tomorrow, my lord, one may say, I'm a field officer. I can be replaced by only field officers, my lord.
No.
But it may, tomorrow one may say so, my lord.
But the person who would be replacing you
My lord.
should have that much of suitability, eligibility, and the previous post which he had held
My
in
lord.
the same rank.
My lord. Correct, my lord, correct. Absolutely. Now, another fact have you seen, my lord? There are some officers, my lord, especially in urban development department. Because of my lord seniority clashes, the matter is pending before the court, my lord. And because of that, my lord, even they have rendered more than 15 years, we could not promote, my lord. These are the circumstances, my lord. I'm okay.
The records, yes. Why the 3-4 files, which is the main file? Now,
I'm sorry, my lord.
you've given 3-4 files, which is the main file?
My lord, they have given the index, my lord. I'm sorry, even I could not peruse properly, my lord. I think they.
Well, we just need the decision-making process. We can at best see the decision-making process. The merits of the decision is separate aspect. Whether in the decision-making process you have taken the relevant factors into consideration or not. That is our lookout, nothing more than that. See, there is one consideration here in one office note. Further, it is proposed to attach Sri T.T. Tupu,
My lord.
DFO Bandardewa Forest Division, to the office of the Chief Conservator of Forest Western Arunachal Circle, Bandardewa, as the officer is due to retire in February 2025. He was not shifted to anywhere else. He was in the same location. So that is why this order was passed at page 27, I think. No, yeah, page 27. What is the name of the private respondent?
My lord, Doke.
Goba Doke, madam.
Gobadoke.
Goba Doke, my lord.
He is a sincere, punctual, and disciplined
My
of
lord.
duties.
One MLA note will be there. If your lordship see the down portion, my lord, I think I have perused that. Saying that, my lord, there is no regular DFO bundle or something like that, my lord. And there will be many other notes will be there, my lord.
Are all the files relevant? Nabam?
I'm sorry, my lord.
Are all the files relevant? Or only the first one? This green file,
Green file,
just see whether it maybe I have not seen any relevance. Just see, cursory glance. Mr. Doloi, which matter are you waiting for?
last
Hearing by the
hearing,
last.
last hearing.
Last 12. So party is insisting me to stay. Let this matter over here, make a fair of it, if possible.
Today will not be possible. Today we are going
No,
to.
today I.
Today we will.
This thing get things right. We are waiting for another.
Because we propose to dictate here in the code itself.
We will wait.
So if you want some date to be given, we can give a date unnecessary.
It be tomorrow.
Tomorrow we fix matters. It is urgent, very urgent or what?
Not very, very urgent, but then, yes, it needs to be disposed of, and then you said the lawyer come all the way to Guwahati, and we don't get him every day here, so.
He can join online, no problem. Online you have such a good facility.
Yes, right. Or me, 22nd, can it be at 2 o'clock so that he can be pretty ready?
We cannot assure you. You have it on Tuesday next. I think that will be the best. 27th.
27, my.
27th.
Yes, my lord.
Well, otherwise on 4th June.
4th is Wednesday. Don't take it on Wednesday because as you know, this Wednesday, Monday, Friday, we do not exactly the
No,
practice here.
22nd or 23rd or the 23rd, we'll make an attempt on 23rd.
23rd, don't take a chance. 23rd, if my brother takes up,
Because,
he is also
but it will not take much time. because
23rd also my brother will have to leave because
your lordship
next
has-
week he is also not there. Don't take on 23rd. I don't have it on 26th or 27th. 27th, Mr. Doloi can easily join in the.
But, I will not be here. I will.
You will say then 4th, you have said. 4th, we can say 4th or 5th. 4th.
We'll make an attempt on 4th.
4th or 5th, I think. 5th may be better for the court.
Yes.
Just on Thursday.
Yes, 5th, okay.
5th, okay.
My lord, can it be on top of the list? I mean,
We cannot say.
as a
If,
first.
if this court is there, we can take the burden on ourselves. We cannot give the burden on anyone else. Not fair.
Otherwise, my lord, day after tomorrow. We'll make an attempt, my lord, because your lordship has already passed certain judgment, which will cover. The only facts has to
Maybe
be.
if can be covered, it can be looked into by other courts also, then not a big problem. Okay, on
Day-
4th.
Day after tomorrow.
Fourth, my lord, 4th or 5th, as your lordship.
4th, okay, paucity of time. Did not permit, would not permit the matters to be taken up today, full stop. Since urgency has been expressed by Sri Patil, not at the, heard Sri T. Patil Learned Counsel for the petitioners, whereas Sri Y. Doloi, Learned Senior Panel Counsel for the Indian of India are present. Para,
Let it be on 5th then.
paucity of time would not permit the matters to be taken up today. Full stop. Para, since urgency has been expressed on behalf of the petitioners, list this case on petitioners and as agreed to by the learned counsel for the parties. list on 5/6/2025. We don't want unnecessary to wait for the council waiting in the court. If there is no chance, if there is a chance, yes, please do. Yes, anything else? I think that is not relevant.
Malot, down portion here, TT Tapu attached care of CCF, WXC, Bandura, may be allowed to continue to hold the additional charge of DF.
রিপোর্ট হয়েছে কি দরকার আছে নকরিবা নহরাগে yes
My lord, now as per this, my lord, note, official note, Mr. TT Tapu was allowed to hold the charge of DF Bandura till his retirement, my lord.
Oh, Tapo's order is there?
Yes.
Please flag it, Yeah, have this.
Page mark.
Flag this on ticket. Asana?
Asana.
Madam, may I please, madam, I further want to clarify one thing, madam, as my learned friend has said, madam, that my joining at my lord is being disputed by my learned friend, my lord. In the
Yes, we want to see the records, whether his joining was received by you.
and in the disposal order, my lord, there is no such, my lord, denial of that fact, my lord, that I have not joined in the
No, when we don't know whether he has joined or not, where is the question of dispute, my lord? We don't
No,
know whether he has joined or
that-
not.
No, is there any joining report there?
That will be available in the office of the CCF office, Bandar, my lord.
DF for Sagan. Mori River. I mark this one X, huh? These are important.
Okay. Please.
My lord, I am marked as X, my lord. These are some official noting pertaining to petitioner and respondent, my lord, proper respondent. As per this noting, my lord, my friend may be right, my lord, he has submitted his joining report. It's reflected there also, my lord. But my question is whether he assumed the duty or not, that is most. Next page also.
Yes. What about the service upon this private respondent? What did you say?
We have filed the affidavit manual.
Okay. The instant petition under Article 226 of the Constitution of India has been filed challenging inter alia an order of transfer dated 24/12/2024 and a subsequent speaking order dated 21/2/2025, whereby the representation of the petitioner has been rejected. Full stop. Para. The case in hand has a checkered history. Para. The petitioner claims to be a selection grade Arunachal Pradesh forest officer holding the post of DCF, Deputy Conservator of Forest, DCF. Wide an order dated 14/2/2024, the petitioner was transferred from Mohau, from the office of the DFO, Mohau, to the office of the DFO, Sagali, and accordingly, the petitioner had joined at his place of posting at Sagali. Full stop. Subsequently, wide an order dated 8/11/2024, the petitioner was transferred from the office of the DFO Sagali Forest Division to the office of the DFO Bandardeva Forest Division. The petitioner claims to have joined at his new place of posting at Bandardeva on 13/12/2024. Full stop. However, wide the impugned order dated 24/12/2024, the aforesaid, the earlier order was modified and the petitioner was retained at Sagali. Full stop. By the said order, the respondent number 3 at serial number 15 was transferred to Bandardeva. Full stop. At serial number 19, it has been clarified that the said respondent number 3, who joined the post after retirement of the incumbent holding the post, namely one Tapu? Titi Tapu, who was to retire on 28/2/2025. Full stop. The petitioner, being aggrieved by the aforesaid move, had submitted a representation on 31/12/2024, followed by approaching this court for the first time by filing WPC 58/2025. This court, wide order dated 5/2/2025, while issuing notice, had passed an order of status quo. Full stop. The aforesaid petition had come up for further consideration on 14/2/2025, when the same was disposed of by directing disposal of the consideration and disposal of the representation, full stop. This court had, however, observed that till such disposal, the order of status quo would be maintained, full stop. Wide the second impugned order dated 21/2/2025, the representation submitted by the petitioner has been rejected, and accordingly, the instant writ petition has been filed, full stop. I have heard Sri R. Saikya, learned counsel for the petitioner. I have also heard Sri R. H. Nabam, the learned AAG, representing the official respondents. So far as the respondent number 3 is concerned, the said respondent has chosen not to appear in spite of service, and in this regard, this court has taken into consideration the affidavit filed on 27/3/2025 as proof of dusty service upon the said respondent number 3. Para. Sri Saikya, the learned counsel, has submitted that the impugned order of transfer dated 24/12/2024 is in violation of the statutory rules and has been affected and has been passed only to favor the respondent number 3. Full stop. By drawing the attention of this court to the Arunachal Pradesh Forest Service rules, the learned counsel has referred to rule Forest Rules Rule 2019, Rule 3(2), which lays down that there would be 4 grades in the service. Rule 2H (small h) lays down the requirement of a departmental promotion committee for both promotion and confirmation. He has also referred to Rule 24, as per which confirmation in service is required to be done by a departmental promotion committee, which is in consonance with Rule 14. Full stop. Reference has also been made to Rule 5 (small Roman 2), which lays down the method of recruitment, as per which there is a quota of 50% by promotion and 50% by direct recruitment. He has contended that the office at Bandadwa is to be headed by an additional DCF, correct? Additional DCF. And in this regard, has drawn the attention of this court to the schedule of the post laid down in the said rules. Full stop. Para. Precisely, the learned counsel has submitted that the respondent number 3 is holding the substantive post of has submitted that while an order dated 9/2/2023, the respondent number 3 was promoted from Range Forest Officer (RFO) to Assistant Commissioner of Forest. Sorry, Assistant Conservator of Forest. And the said promotion was for a probation of 2 years, which is to be followed by a confirmation in service. Full stop. He has reiterated that such confirmation would be done as per Rule 24, read with Rule 14 of the aforesaid rules. He has submitted that as on the date when the impugned order was passed on 24/12/2024, respondent number 3 was still in the probation period as an ACF, which is otherwise also lower in grade to the post of Deputy Conservator of Forest within the DCF held by the petitioner. He has submitted that noticing the illegalities, this court in the first round of litigation had initially passed an order of status quo, which was continued by the final order dated 14/2/2025, while there was a direction to dispose of the representation. Full stop. Para. Sri Sakya has been critical of the order dated 24/12/2024, by which where is the representation order?
Disposal matter.
Disposal.
Page 57, madam.
57.
21.
Has been critical about the order dated 21/2/2025, by which his representation, the representation of the petitioner has been disposed of. He has submitted that the order is cryptic, and apart from laying down the facts which led to the aspect of consideration and disposal of the representation, no discernible reasons have been cited for such disposal. He has submitted that a decision of the High Court of Madras has been taken into consideration, in which it has been laid down that when two posts are considered equal under the rules, an employee cannot demand a specific position as their right or personal preference. In the said order, a case of the Honorable Supreme Court has also been referred, wherein it has been held that employees do not have a fundamental right to request a transfer, and that government employees cannot demand a posting of their choice. Para. The Learned Council has submitted that neither of the ratios would be applicable in the instant case, which is on a different footing altogether. Full stop. Where is it up? Well, the Learned Sri Sakya, the Learned Council accordingly submits that the impugned action is liable to be interfered with, and his client be permitted to serve at his place of posting in the office of the DFO Mandarjeva. Per contra, Sri Nabam, the learned AAG, has strenuously opposed the writ petition, full stop. The learned AG has firstly submitted that in matters concerning transfers, comma, the scope of interference is very limited, and unless there is apparent violation of the statute or mala fide or apparent mala fide involved in such transfer, those are not to be interfered with by a court, as the aforesaid action of transfer would fall within the domain of the executive, as it is the best judge as to how to utilize the services of the employees. Coming to the facts of the case, the learned State Council has submitted that though the order dated 21/2/2025, by which the representation was disposed of, may not be a very elaborate order, there are bona fide reasons for which the order dated 24/12/2024 was passed. Full stop. Firstly, he has submitted that the petitioner had joined the office of the DFO Sagali only on 14/2/2024, and within a span of 9 months, he was again transferred to the office of the DFO Bandardeva, vide the order dated 8/11/2024. Full stop. The State Council had also initially disputed the aspect that the petitioner had indeed joined at Bandardeva. Full stop. He has submitted that the impugned order dated 24/12/2024 would make it clear that the petitioner was retained at Sagali, and therefore there could not have been an occasion for him to join at Bandardeva. Full stop. To buttress this 8 point, the learned State Council has also submitted that there was that it was not possible for the petitioner to join at his post at Bandardeva as claimed on 13/12/2024, as the incumbent in place of whom the petitioner was to join was to retire only on 28/2/2025. Full stop. He submits that the aforesaid aspect has been clarified in the impugned order dated 24/12/2024, whereby it has been stipulated that the respondent number 3, who has been transferred to Bandardeva, would join only after retirement of the earlier incumbent, namely Sri Titi Tapu, on 28/2/2025. Full stop. With regard to the status of the services of the petitioner vis-a-vis the respondent number 3, the learned State Council has submitted that though it is a matter of fact that the promotional order dated 9/2/2023 of the respondent number 3 from RFO to ACF was on probation for 2 years, which of 2 years, such period, the aforesaid period of 2 years was over on 8/2/2025. And therefore, there was no hurdle, no obstacle or bar for the respondent number 3 to join the post at Bandardeva on 28 to 2025. He has also submitted that though the schedule of post as per the rules of 2019 stipulates that the office at Bandardeva is to be headed by an additional DCF for exigency of service. An officer who is in the cadre of ACF can also be appointed, which has been done in the instant case. He has also submitted that both the incumbents are presently working in their respective places, and otherwise also the impugned order of transfer is not liable to be interfered with. Full stop. The learned State Council has placed before this court the records of the case in origin. Sarah? Sri Saikya, in his rejoinder, has submitted that the contention advanced by original. The Sri Nabam, the learned AAG, has, however, very fairly pointed out that though initially he had submitted that there was doubt on the aspect of joining of the petitioner at Bandardeva, the records would, however, indicate that he had submitted a joining report. That's what he did. So, Sri Saikya, in his rejoinder, has submitted that the aspect that the incumbent Sri T.T. Topu was holding the post for which the petitioner could not have joined at Bandardeva is incorrect, inasmuch as the initial order of transfer dated 8/11/2024 itself had stipulated that the said incumbent Sri T.T. Tapu was attached to the office of the CCF WAC. Since the learned AG had also raised an issue regarding the petitioner, questioning whether the petitioner was actually holding a post in the selection grade, the learned counsel for the petitioner has drawn the attention of this court to the annexure five, whereby certain officers have been earmarked to be eligible for promotion to the administrative grade. And in the said list, the name of the petitioner also figures. He has immediately drawn the attention of this court to rule rule 3 within bracket 2 of the rules, which lays down 4 cadres and 4 cadres to buttress the aforesaid point. Full stop. Reference has also been made to Rule 33 within bracket 2, wherein it has been laid down that only selection grade officer would be eligible for administrative grade. He has also referred to Rule 31, within bracket small 1, Roman, whereby another stipulation is laid down that an incumbent should serve 5 years as entry grade to be appointed as an SEF, appointed in the Arunachal APFS, within bracket senior grade, correct? Senior grade. Correct. The rival contentions advanced by the learned counsel for the parties have been duly considered, and the materials placed before this court, including the original records, have been carefully perused. Sarah? Before going to the issue which requires a determination, certain facts which are not disputed are required to be placed on record. Sarah? As indicated above, the petitioner was transferred to Sagali on a wide order dated 14/2/2024 and by the subsequent order dated 8/11/2024, he was transferred from Sagali Forest Division to Bandardeva Forest Division. And the petitioner claims that on 13/12/2024, he had joined at Bandardeva. Full stop. Since an issue was raised on the aspect as to whether the petitioner had joined at Bandardeva, the records have been perused and as have fairly pointed out by the learned AAG, the records would indicate that the petitioner had indeed submitted his joining report on 13/12/2024. Full stop. This brings this court to the aspect as to whether such joining was possible, inasmuch as the incumbent in whose place the petitioner was to join was to retire only on 28/2/2025. Full stop. The said aspect stands answered by the order dated 8/11/2024 itself, as per which the said incumbent Sri T.T. Tapu was attached to the office of the CCF, WAC. Full stop. This court has perused the original records, and there is a noting that such arrangement was made only taking into consideration that the said incumbent Sri T.T. Tapu was on the verge of his retirement, which was on 28/2/2025. Full stop. Therefore, there was no occasion, therefore it could not have been a reason that the petitioner could not have joined at Bandardeva. Full stop. Para. The initial writ petition WPC 58/2025 was moved on 5/2/2025, on which date this court had passed an order of status quo, which was continued till the final order dated 14/2/2025, and with the stipulation that the same would remain in force till the representation is disposed of. This court has also examined the order dated 21/2/2025, by which the representation has been disposed of. Full stop. The grounds of challenge as would be discernible from the representation dated 31/12/2024 and the pleadings in the writ petition are not the grounds which have been cited while rejecting the representation. Full stop. While there is no dispute to the proposition of law that transfer is an incidence of service and are not to be interfered with by a court in exercise of judicial review unless there is violation of the statutory norms or mala fide involved, comma. The grounds of challenge in the instant case were wholly different. Full stop. Apart from the ground that such transfer that the impugned order dated 24/12/2024 was passed within a period of less than 2 months, comma, the same appears to have been passed only to favor the respondent number 3. Full stop. The perusal of the records would also make another revelation. The accommodation of the respondent number 3 was only because of a representation made by the local MLA. Full stop. While such representation is not while this court is not averse to submitting of such representation by a public representative, the same are to be considered in the proper perspective and in accordance with law, and not at the prejudice of any other affected person. Full stop. This court would haste to add that such prejudice has to be legal prejudice and not mere suffering of certain inconvenience. Full stop. In the instant case, the aspect that the petitioner had joined at Bandardeva on 13/12/2024, which is supported by the records, was totally ignored, and the impugned order of 24/12/2024 was simply passed by retaining him at Sagali. Full stop. Sagali. Full stop. Para. So far as the contention advanced on behalf of the state that such arrangement had to be done by taking into account that one of the incumbent who was posted at Bandardeva was to retire on 28/2/2025 is not acceptable by the court, as the same arrangement could have been maintained even by directing that the petitioner would join at Bandardeva on retirement of the aforesaid incumbent Sri T.T. Topu. Full stop. In any case, the order dated 8/11/2024 had taken this aspect into consideration, and the incumbent was not as such transferred from the locality, but was retained but was attached to another office in Bandardoa itself, which is the office of the CCF WAC, full stop. In any case, comma, as on today, the said incumbent has retired from service, and therefore the post would have post and from the said date of retirement, the post had fallen vacant. Full stop. Para. In the conspectus of the aforesaid discussion, and also taking into account that the response number 3 was not even in the cadre of the petitioner, and the post where the petitioner was transferred via the order dated 8/11/2024 is not in the cadre where the respondent number 3 is performing, namely ACF. This court is of the opinion that the imputed action of the respondents is unsustainable in law. In this connection, reference may be made to a judgment of this court passed in the case of Hibu Tama versus State of AP, reported in so and so, in which in a similar circumstance, the transfer order was found fault with and interfered. It will be mentioned that in the aforesaid case of Hibu Tama, reference to many earlier cases were made, including the order dated. Where is that order? That's the Greenhouse order. Including the order dated 28/9/2026, passed in WPC 257 AP of 2016, page 38. Full stop. In view of the aforesaid discussion, comma, the repetition is allowed, and the impugned orders of transfer, impugned order dated 24/12/2024, and orders and 21/2/2025 are set aside. Full stop. Consequently, the petitioner is consequently, the respondents are directed to allow the petitioner to serve in the office of the DFO, Bandardeva. Full stop. Petitions, the original records are handed over back to the learned age. Okay. ये रखना है, इसमें देखना।
Only problem would be, my lord, the private respondent assume the duty, and if petitioner allows, my lord, then Sagali division will be back in, my lord.
He should have come at least. He is not even come. Okay. Yes. Rest, some dates will be given for urgency, to put up the budget. Any urgent matters?
My lord,
Which one?
my lord, item number 20.
Yes. Now, when do you want? No, but tell us when do you want? Next Tuesday?
Yeah.
Day after tomorrow, not possible. Don't take this week. We have fixed many matters. Division bench should continue for long. On Tuesday next.
Lord,
Okay? You're for the other side.
Lordship, I am for the petitioner, Lordship.
Tuesday next,
Lord,
2/8.
Lordship,
28 is Wednesday. Wednesday is possible. Okay?
Wednesday.
28, 2/8.
There is state expired. And on the previous day, there is a specific order. That my lord, because on here also we, there is a specific order that the issue of extension of the party interim stay will be taken from the next day. Because my lord, this is of regards to our line. My lord,
Oh, have it on Wednesday or no, Tuesday, whenever you.
Lordship, can it be on 28th?
2/8.
Yes.
Yes, possible Wednesday.
Yes, 28th.
Okay.
I don't know.
Paucity of time would not permit the matter to be taken up today. Full stop. As urgency has been expressed on behalf of the respondent, list on 28/5.
Interim may be extended.
Interim order stands extended till the next date fixed.
Yes.
Okay.
Deeply obliged.
That obviously, it is
Yes,
only till
Lordship.
the next date.
Yes, yes.
If
Lordship-
is there, a hearing will definitely be
Lordship,
taken place.
Lordship, the issue is they have filed an interlocutory application for vacation. So I may be, in the meantime, I'll be filing reply to that interlocutory application.
The writ petitioner, one or two, how many writ petitioners?
One.
Writ
Single.
petitioner may file objection to the IA in the meantime.
my lord, we have also filed a
Yes, sir. Please.